It's Friday night live. We are live. There's a ton to talk about. My cats are doing some super sketchy stuff behind my computer. I am not sure how this is going to go. I'm like, oh gosh, I feel like if all of a sudden my camera gets disconnected, it is because my cats are messing around behind my computer. Hopefully tonight is finding you well. We have a ton of topics to cover tonight, and it's going to be more quick bits. There was one topic I wanted to get to that I'm going to have to bounce because there's a new filing in the Duggar case too that I just wanted to touch on real quick so we know when to expect things in that case next. We also have the Nirvana baby lawsuit. There's a lot of questions about that. There's a new filing in the Britney Spears case that's a stipulation that we have to talk about. One of the jurors from the Holmes case spoke out, and we're going to touch on that real quick. And then there is wildness happening in the G Max case, and we will talk about that more. For those of you that were here on Tuesday, you know why we're just calling it G Max. We're just like gigamaxing that case. But the potential mistrial is real, and we're going to talk about it. I was talking to a few prosecutor friends of mine. I was like, you're never going to believe this. They're like, oh my God. Oh my God. Oh my God. I'm like, I know. So we're going to talk about what all of that means. And I actually pulled the jury questionnaire. So we're going to go through some of what the jurors were asked, and we're going to go through the statements the juror made. So that's going to be kind of our deeper dive for the evening. And then time for questions. I am cutting a topic to make sure there's time for questions. We were chatting on Patreon in the Law Nerds community about what we were going to talk about tonight for the tiers that have kind of input into the topics. And there is a Westbrook update that I've been dying to get to, but there is stuff that is so much more timely, and there's other filings that are going to be coming in that case, I'm sure, in response. So that is getting a little bit bumped. It's just getting a slight bump. Shh. We don't talk about Bruno. It's going to be fine. It's going to be fine. We should just get going. Let me know where you're coming in tonight. I have all of the waters tonight because it's just been so dry, and it is water time for me this evening. And I had a slight allergic reaction to something I ate today. So I'm like, I cannot drink. My face is already burning pink. I feel like in Clueless, where Cher's trying to get ready for her date that's not a date, and she's bright red, and Dee is powdering her face going, I'm trying to make you as white as I can. She's like, I'm still all pink. That's me today. We're still all pink. And we're coming from a very snowed in Middle Tennessee, which I absolutely love. I love seeing all the text crew in the chat. Hello, replay crew. Love you. Timestamps will be down below. Next week is our members only live stream. So if you're a member on the YouTubes or over in the Law Nerds community at lawnerdsunite.com, you will be able to take part. And we will be talking tea. We will be giving a preview of the updates I haven't gotten to yet. And I will be taking a poll on what else the members would like to chat about in our top secret members only live stream that you can join too. So let us just get into the night. Let me know where you're coming in from. I already can't talk, so it's going to be great. It's going to be awesome. We should just do the thing. You ready? Are you ready I'm ready. I'm ready for the music. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. I love how much snow has snowed in. Okay, look, here's the thing. We don't get a ton of snow here. We get snow sporadically where I am. So we got 6 inches, 7 inches, which is a lot for us. It's a lot to take. We can't all take 7 inches up here in Middle Tennessee. We are not talking Michigan level snow. We are definitely not talking Wisconsin level snow, Minnesota level snow, North Dakota level snow. We are talking the South level snow. And for the South level snow, it's a lot. And it's like it snowed. It's enough that the roads aren't all plowed. Not all roads can be plowed. And then it freezes and ices and it's just a mess. So that is a lot for us. It was really fun to go out yesterday. If you guys follow me on Instagram, you would have seen me running around in the snow a little bit yesterday. It was so much fun. I love it. Bubbly sounds so good. It sounds so good. It sounds so good. And Mommers over in Eagle River, Alaska is laughing at all of my 7 inches, but it was a lot for us. It's like when you don't get snow a lot, and then it feels like a lot. So for us, it was a lot. I tried to not make all the jokes on Instagram about how much snow we got. And then everybody was like, why didn't you just make all of the jokes? And Travis said, your channel is my new favorite. Thank you. I grew up in East Tennessee. Hello from Columbus, Ohio. Well, yeah, East Tennessee probably got more snow than we did, I think. Tori is saying, I'll take the 7 inches. I mean, I think my husband said the exact same thing. And I was like, oh, honey. It look, we've got to make some of the jokes. We've got to make some of the jokes up here. We know how it is. We're here for adults. I love all the Canadians who are like, look, it's negative a million degrees where I live. It's okay, Canadians. You guys can't go outside anyway. So just stay in and stay warm. That's a terrible joke. I didn't mean it that way. It's cold. Hello, Melbourne, Australia. So tonight we're going to do Maxwell last. Should we do Big Nirvana Baby first? Because we can make fun of it. Because we've got some more serious topics. But I feel like at least with Big Nirvana Baby, we can have a little bit of a joke because it's the Big Nirvana Baby. Do you guys remember covering the Nirvana Baby case? We should get into our weekly roundup because we're going to do a few weekly roundups before we get into the Maxwell mistrial mischief. So we should round it up. Why am I so short tonight? Did my camera move? Is my posture terrible? I don't know what's happening. I feel like, okay, it's my posture. It's me. I'm just like, it's Friday. It's Friday. We're just going to do that. It's Friday. All the things. We should weekly round up this stuff right now. So with the Big Nirvana Baby is the baby from the cover of the Nevermind album. I did a podcast episode on this. If you want the backstory of this lawsuit alleged that the Nevermind album cover with the baby swimming towards like the dollar, that the Nevermind album cover was exploitative, inappropriate CP, and that the Big Nirvana Baby was suing over that. So with that, all of the defendants, including the estate of Kurt Cobain and, Universal Music Group, the David Geffen Company, Geffen Records, Courtney Love as the executor of the estate of Kurt Cobain, Dave Grohl, like you sued Dave Grohl, Kirk Weedle, and others, all filed a motion to dismiss. So let's go over the court's ruling real quick. Oh, I should see if there's been an update before I do this. Let's pull up Pacer and we will just double check as we get into this too, because why not? I meant to do that. And then I ended up pulling up something else. Girls ADHD. We ended up pulling up something else. And that's where I was like, oh, there's a new Duggar motion. Of course there is, because the cases, the way that they're stacked, it's just like, I meant to pull up the Nirvana case and then didn't. The true story. And now as I'm live, I'm like, we meant to pull up and see if there was a new one, and there is not any new order. So we're just going to go with the order from the court before we move on, because there was some confusion. I posted about it on the Twitters, I believe is where I posted. There was a little bit of confusion about what this means. So I'm just going to clear it all up. That's not what I wanted to do. No, we don't want to pull up slides. There's new options in StreamYard. I love using StreamYard, but I don't need all the options. We're not doing a slideshow. Sometimes maybe we need to. No, we don't. That's very rarely going to happen. Maybe this semester when I talk at University of Memphis. I will prepare a slide. I won't prepare a slide presentation. I'll joke about it, but I won't do it. So here's the court's order. Here's what's strange about this. The motion was set for oral argument on January. No, but we can't. We started with the jokes. We can't. It's an out. We will do an After Dark episode again in February. We're not doing one tonight. This is not the appropriate case to make those jokes based on the nature of the allegations, even though I think they're stupid. I'm just trying to not rein it in, girl. Rein it in. The oral argument was set for January 20th. The January 20th hearing date required plaintiff to file his opposition to the motion no later than December 30th. So all the defendants filed a motion to dismiss. Like, yo, could you dismiss? We didn't even cover the motion to dismiss because there was a statute of limitations issue anyway. And I was like, there's going to be a motion to dismiss, obviously. And with that, we just didn't get back to it. So if we need to go over that, we will. But at this point, the court has made this order, so we're just not doing it today. So no later than December 30th, the plaintiff didn't file an opposition to the defendant's motion to dismiss. So the court will vacate the hearing date and grant the motion to dismiss. In addition, given that policy favors amendments of complaints, the court will grant defendant's motion and give defendant one last opportunity to amend his complaint. In preparing the second amended complaint, plaintiff shall carefully evaluate. Plaintiff, you shall carefully evaluate. This is the court being like, check yourself before you wreck yourself. You need to consider, govern yourself accordingly when you file this amended complaint. In preparing the second amended complaint, plaintiff shall carefully evaluate the contentions, me getting things wrong, set forth in defendant's motion, including defendant's assertions that plaintiff's claims pursuant to 2255 and 1595 are time barred. You know why? Because they are. There's no getting around the statute of limitations. The court expects that defendants will agree to any amendments and that will cure the alleged defects. So, hey, look at what the defendants argued in their motion to dismiss, fix that shit, and then file an amended. Can you just? And with that, the court dismissed the case with leave to amend. So all the headlines pissed me off. All the headlines were like, the case has been dismissed. The case has been dismissed. No. And yes. And that's the thing that annoys me so much. That's not the whole story. It's been dismissed with leave to amend. It's not just like over. It's not over until the next date when the leave to amend is filed or not filed. If plaintiff still wishes to pursue this action, he is granted until January 13th to file a second leave to amend. Let's all set a calendar reminder. Hey Siri, set a reminder for January 13th. Big Nirvana baby motion due.
Okay, your reminder is set.
Perfect. So let's all set a calendar
for Thursday.
A calendar reminder for January 13th to see if the Big Nirvana baby files a second amended complaint. If the Big Nirvana baby does not file a second amended complaint, then this lawsuit will at that point be dismissed. So, to the extent that Big Nirvana baby believes that it's warranted by existing law and the defects outlined in the defendant's motions can be fixed. The second amended complaint must be labeled second amended complaint. It needs to be the SAC and contain the case number. We know all of this. I think it's funny that the judge is outlining the local rules, and I wonder why the judge is outlining the local rules or if that's just the judge's policy. Plaintiff is cautioned. Govern yourself accordingly. Plaintiff is cautioned that a failure to timely file a second amended complaint shall result in this action being dismissed without prejudice for failure to prosecute or failure to comply with the court order, which is so annoying because they'll be able to file it again if it's filed without prejudice. So, though the court is saying essentially, look, the statute of limitations is an issue. You need to figure it out immediately. So, if he files a SAC, the defendants shall answer it by January 27th. So we'll see next week if this case is done or if this case is not all the way done. I am so sorry that I said all your reminders. I apologize for all of you who are like, no, I didn't need reminders. Apologies. Thank you for the tech help, Katya. You always get it handled. I apologize. That was not my intent. It was really just my intent to remind me. So, we will see. In the event, here is our last footnote. In the event that the defendants wish to file another motion to dismiss, then counsel for the parties shall, on January 20th, 2022 at 10 a.m., meet and confer in person or via video conference to discuss defendant's motion to dismiss. Of course, they're going to file another motion to dismiss. You can't make time, like time is a construct, but also you can't make time work differently. This dude is like 30 years old. The album is like 30 years old. It makes me feel very old. And he knew that this happened. He's gone to multiple like signings and cons and all of this stuff to be the Nirvana baby. He's done interviews. He's aware that this photo was taken. The statute of limitations I covered in the episode of the Emily show. I don't think there's any getting around it. I don't think it can survive. I don't know what lawyer decided to file this. It'll be interesting to see if any of these defendants file a motion for sanctions for attorney's fees saying, look, you knew that there was a statute of limitations issues when you filed it. Like, look at the law. You knew that you couldn't file this and yet you did. So we'll see. Counsel, the final footnote. The final footnote. Counsel may agree to meet and confer at another time and place without seeking court approval for such agreement. Y'all be adults, pick a date. I think this will get dismissed next week. I don't think it will get refiled. I don't know the point of filing this. I don't think. I wish we knew, and we're never going to know, but I wish we knew what his attorneys said to him when either they found him or he found them and said, I think I need to do this. I just really wish we knew how it came to be that this decision was made. I want to know, like, how did this decision get made? Did lawyers reach out to him and be like, hey, we think you should do this? Because that does happen. Or did he seek out attorneys and say, in hindsight, I'm not okay with this. I need to know things that we're never going to know. But I wish I knew. Ugh. This is the kind of stuff where, when you have a valid claim, you should absolutely 100% litigate your valid claims. If something has harmed you, if wrong has been done to you, if your intellectual property is being used, on and on and on, use the court system. But using the court system when you know that it can't succeed is beyond the bounds of what appropriate litigation is. And I think courts sometimes aren't stringent enough on the kind of vexatious litigation and holding plaintiffs accountable when they file stuff that can never have a chance of succeeding because it costs people time and money and energy. But I think in the H3 cases, we will probably see that change more. All right. Should we get to this Duggar motion and then the McMichaels sentencing? No, the Duggar motion and then Holmes and then McMichaels and then Britney. I think that's the order we're going to go in. That feels right as I'm saying it out loud, and we're going with that, and we'll do Britney and then Maxwell because we'll probably have the most questions about Britney and Maxwell. So, for those of you that are new in the chat, just a reminder, I do all of the questions at the end so that I do not get sidetracked. and never finish the things that I wanted to finish. So if I start doing questions under each topic, and I've tried that, I will never get to the end. So let us move on to the Duggar update, and then what did I say was next? Duggar, then McMichaels sentencing. And we're going to do a quick video for the McMichaels sentencing, and then we'll get to Britney. So I've rearranged my notes so that I know which order we're going in. And we should I have Encanto music stuck in my head. It's just, if you follow me on social, you'll know that I'm a bit obsessed. I'm not surprised. Just for a quick second, we have to talk about the fact that as I was going down an Encanto rabbit hole of the music, because of course I really enjoy the writing of Lin-Manuel Miranda. I think he is brilliant. I love it. I loved Moana. I loved Hamilton. I love the cleverness of the writing. I love that it is faster paced and his music feels very modern compared to kind of older Disney movies where the music doesn't feel quite as modern. I enjoy it. Like, I will sing every single lyric to The Little Mermaid and Beauty and the Beast. Like, don't you doubt it. But the music feels so modern. And in that, I went down a rabbit hole and I found this. And if you follow me on Instagram, you already know what I'm going to talk about. But I had no idea this existed. And I am very disappointed that I didn't know that this existed, because this is another Lin-Manuel Miranda musical. Look, Bring It On the musical exists, okay? Bring It On the musical exists. I didn't know it existed, but I said, "Brr, it's cold in here." I said, "There must be some toros in the atmosphere." I said, "Brr." I can't stop my feet in time. I am not a Clover. I am not talented. I was not a cheerleader. I was on Tall Flags and in band. But there is a Bring It On the musical written by Lin-Manuel Miranda. I'm sorry. What? I need to see this. Oh my God. JC said it's playing in London at the moment. I need that to happen. I love the Bring It On movies. This is something maybe you don't know about me. I love the Bring It On movies. They are so 90s, delicious, early 2000s, I guess. They are delicious. The beginning sequences with the kind of satire of cheerleading when they're doing the intro cheer, that's really her like fever dream, is one of my favorite things ever. I swear I'm not a whore. Woo! I love the beginning of Bring It On. Oh my God. Oh my God. Anyway, I had no idea that Bring It On was a musical that was done by Lin-Manuel Miranda. So I've been listening to this as well, and I love it. Oh, Jay, I know Legally Blonde's a musical. I love it. Legally Blonde, the musical, is fantastic. I was unaware that there was a Bring It On the musical, and I think it's great. So, yes, that is the rabbit hole that I went down, because Apple Music was like, "Oh, hey, you're going down this rabbit hole. Would you also like to go down this other rabbit hole?" Yes, I would. Aggressive jazz hands. I love all of it. We actually had there was my friends from high school. There was a flag routine that involved aggressive jazz hands at some point, and after Bring It On came out, I was like, "Jazz hands." So yes, Rotten Ralph, Bring It On the musical is a Lin-Manuel Miranda musical circa 2012. And I'm thinking to myself, like, what was I doing in 2012? Why didn't I know this? And I was like, oh, I had a really, really high risk pregnancy and a child and a job. I was not in the world. I was in my very own world with that. So anyway, I had to have a Bring It On tangent. I also love Stick It. Some you guys are talking about Stick It in the chat. I love Bring It On. I love Stick It too. Those aren't spirit fingers. These are spirit fingers. You're right. These are spirit fingers. These aren't spirit fingers. These Our spirit ring. I will this might have to be a deeper tangent on our members only live stream. I have never seen the movie Fired Up, but I'm adding it to my list. Oh my goodness. So that is where my brain went. Fred, what are you doing? Oh, Fred's like, he's like, I'm needing my blanket so I can lay back down. So I'm laying back down. I'm laying back down. That's what Fred's doing. Anyway, I'm thrilled that I know that this exists. You guys are the greatest. I'm still Big Red. We cheer and we lead. We swear we're not on speed. We're cheerleaders. What cheerleaders? I know Bring It On too well, and that intro sequence also super clever. Super clever. Okay, so we need to move on. We tangented. We're back to the world. I've been watching lots of Encanto. I absolutely love it. I'm obsessed. I think it's great. I like the direction Disney's been going in. What were we talking? Duggar, we were talking about Duggar. All right, we needed a little light spot before we talk about Josh Duggar. We're going to just talk about this real quick because at least we now have an answer for when the next motions are coming. I should swoop to make it all okay. We have swooped. I should pull this up on the screen. Yes, Emily. We are professionals here. Let's make this bigger. Defense filed an unopposed motion for additional time to file post-trial motions. So we have a little bit of a reprieve for the post-trial motions, I should say. The post-trial motions are going to occur before sentencing. There will be multiple post-trial motions, likely. I mean, this is the defense team that brought us the appointments clause motion. I suspect there will be multiple post-trial motions. These can be motions for new trial because of this, that, and the other thing. And we will evaluate those as they come in. All you guys are getting the full judicial system experience with the Duggar case, and close in time too. This prosecution moved very fast. So we've done everything from pre-trial, from like arrest, we covered arrest, detention hearing, through pre-trial motions and the motions in limine, through the trial, through the conviction, and now through the post-trial motions, the sentencing memorandums, and then the sentencing at some point in 2022. So we're getting the full experience, and we're going to do it all within probably a year of his arrest, which is very fast for a criminal trial in any system, but particularly in the federal system. So Duggar is asking for an additional 10 days to file post-trial motions. They were due January 9th, 2022. There's a footnote. We're going to just... I doubt it's going to be sassy, but we'll see what it says. You're footnoting to the thing you just said. That's not a foot. Okay, let me just read the whole thing before I judge. The deadline is currently January 9th, 2022. However, because that falls on a Sunday, the deadline in the absence of an extension is January 10th, 2022. Okay. Thanks for that. I guess it's footnote worthy. On December 9th, following a jury trial, Duggar was found guilty on both counts of the indictment. Footnote 2. Based on the way the indictment was charged, this court stayed the possession conviction as it is a lesser included offense and will be dismissed prior to sentencing. Like I said, he can't be sentenced on both. So his maximum possible sentence is 40 years. Because you know what? I know some shit, and I'm right about that. I'm not right about everything, but I'm definitely right about that. There's one thing I'm super right about, and that is the sentencing in the Duggar case. Others don't know what they're talking about. So let us continue. With that, on December, we got to footnote 2. At that time, undersigned counsel orally requested 30 days to file post-trial motions, and this court granted that request. The defense has ordered the trial transcripts in this matter and has been informed by the court reporter that the transcripts are expected to be completed next week. Because the transcripts are necessary, that's fair. They are. I said not 40-20. Not I should have said not 40-20. Not 40-20. Has ordered the trial transcripts. They've been informed they will be completed next week, which is fast. Trial transcripts do take time because the transcripts are necessary with respect to certain issues. I'm not surprised by that. That is very common. The Duggar intends to raise in post-trial motions. Duggar respectfully requests the court grant the brief extension. That's going to get granted. In which to file his motions so that the transcripts may be utilized so that the court will have a more precise record from which to consider the motions. Specifically, Duggar respectfully requests until January 19th to file any motions. I'm going to set a calendar on January 19th. We'll see those motions. What day of the week is that? What day of the week is January 19th? Where's my calendar? Is my calendar even up? No, my calendar's closed. Of course my calendar's closed because I'm streaming. Emily, why would you need your calendar? What day of the week is that? Be a Tuesday. File them so we can talk about it on Coffee and Cursey Words. Everyone file your motions to coincide. Oh, it's a Wednesday. Perfect. So we'll just talk about it during, probably during Friday Night Live, unless they're explosive, and then we'll just talk about them on Wednesday. So Wednesday the 19th is when we will start seeing some motions from the defense. Here's what will happen. We will get motions from the defense. Then we will get motions from the government. So the defense will file, the government will have the time to oppose the motions, respond to the motions. Then the defense will have time to reply to the motions. Then the motions will be heard by the court unless the court is like, no, yeet, we're not hearing that motion at all. And then we will start getting sentencing memorandums. So, this is all part of normal procedure. It is not, there is nothing strange or abnormal or weird. This is part of criminal law and practice. A conviction, back to Clueless, a conviction is like a starting off point of negotiations. It's the jumping off point for a lot of post-trial litigation. A lot of the time, the post-trial litigation does not go anywhere. They are motions that preserve rights on appeal. Things can go up on appeal. And oftentimes those things do not overturn cases on appeal. Sometimes they do. I have not seen anything in this case that even raises an inkling of an issue that anything will be overturned on appeal, but the court will hear these motions. It is part of kind of the law in motion of criminal trials. This is what this is. So nothing strange, but at least now we know the date we're getting those motions and we can all go, okay, we will check back in with the Duggar world on the 19th. That's what we'll do. We're just not going to peek back in until then. So let's talk about the Holmes juror speaking out, because the Holmes juror is not causing controversy, but gave us some information that we didn't have. And I find that to be very interesting because I'm nosy and I wanted to know things. Like, truthfully, with the Holmes case, I'm nosy and I wanted to know things. In the Holmes case, the jury deliberated for quite a while and came back with that not just partially hung jury, but also a split verdict. This jury gave us all the things. Some not guilty, some hangs. It was everything. And it was very interesting hearing the jurors speak out. If you guys listen to the Dropout podcast, they covered the interview with that juror on there, and we're going to talk about it here. I should pull up the sentencing forms just so we have them for ease of conversation. So let's review the verdict real quick as we update, because not all of you watch every hour of everything that I do, which is totally fair, by the way. Let's go to these verdicts real quick so that at least as we're talking about the verdicts, we're all on the same page. All on the same page. All right. Count 1 is guilty, conspiracy to commit wire fraud against investors. Count 2, not guilty, conspiracy to commit wire fraud against patients. Count 3, unable to decide. Count 4, unable to decide. Count 5, unable to decide. Count 6, guilty of wire fraud against Theranos investors. Count 7, guilty against investors. Count 8, guilty against investors, which is really like these particular investors, which are for these amounts of money, the $100,000, which is the DeVos family, the 38 some odd million, the 5.9 million. And then counts 10, 11, and 12 are the not guilties with regard to the patients. Counts 10 and 11 are lab results being transmitted. They found not guilty there. And then count 12 is the money spent on advertising for the patients in the areas where you could get Theranos tests. For those of you asking what a hung jury is, I saw a couple of you. A hung jury is a jury. I don't know what the history is. I will have to look it up at some point. Is a jury that is deadlocked and unable to decide. Deadlocked sounds better. Anyway, deadlocked and unable to decide what the verdict should be. For a criminal case in the US, there are 12 jurors that decide, and all 12 of them have to agree unanimously, guilty or not guilty. So if you have 3 people who are like, nah, guilty, and then the rest of them are like, not a chance, that's a not guilty, that is a jury that cannot agree, and they become deadlocked. I'm not changing my mind. Okay, well, I'm not changing my mind. And then the jury becomes deadlocked on those counts. So this is a split verdict in that some of the counts were guilty, convicted. Some of the counts not guilty, acquitted. Some of the counts deadlocked, unable to decide. And the jury, the government can retry Elizabeth Holmes on those 3 cases or those 3 charges. Will they choose to? Will they not choose to? I don't know if it's going to be worth their time, energy, and money to decide that. I don't know if it'll be worth their energy to retry those 3 cases for the or those 3 charges for the investors, because with that, they're not going to get much more time in custody on a white collar crime case for the additional money under the sentencing guidelines. You already have what, we're just rounding here. So this is a 3. We're just keeping this at 38 million, 100 million, and what, 6 million. So that's, over 143 something million. So once you get over that 65 million mark, the sentencing guidelines go up. So adding in this additional money, 4 million, 5 million, and another, and $100,000, and only $100,000. But when you add in that additional money, it's not going to increase the time. So it's not going to increase her punishment. So does it matter for the government to go through and retry those? They could choose to do it. They could choose to not do it. They're probably not going to sentence her till after her co-defendant is tried anyway. Sunny Balwani, she's going to stay out of custody. She's going to appeal things. So we will see. We will see what the government decides to do. There's a hearing coming up where the government will indicate what they are going to do or what they intend to do. And they might say, we will decide after the Balwani trial. The government's learned a lot from this jury, I'm sure, and might convict him on those and then might decide to not convict her on those. So we'll see. So we'll see what happens. But those are the particular convictions. So let us go to what this juror said. There's been a few articles on this. I'm pulling from ABC News because ABC News is the news outlet that likes me the best. No, I'm teasing, sort of. No, ABC News is the news organization that produces the Dropout podcast. So they're the news organization that spoke directly to this juror and obtained the story instead of a retelling of the story. Something smells like fire. What is my husband making in the kitchen? I'm like, what? So this is from the juror speaking out after the conviction of Holmes, saying it was an honor, it was a duty, I did it, I'm done. I'm sure this juror will never want to do jury duty again after how long they were on a jury. Here's a little inside baseball secret. Once someone's been on a jury that reaches a verdict, it makes both sides. Both sides, if you're in a criminal case, the prosecution and the defense, and if you're in a civil case, the plaintiff and the defendant, it makes both sides a little more comfortable. It's like, oh, this person's been able to sit in a room with 12 people and reach an agreement. We might want them on jury duty again. So it's asked in almost every voir dire I've ever seen. It's asked, have you been on a jury before? Was that jury able to reach a verdict? They don't ask, was it a guilty verdict or a not guilty verdict? They ask, was a verdict reached? Okay, so we know you're able to reach agreement with 12 other people. We like you. You are a more known entity to us. So we're going to keep you on this jury. So it increases the probability that you might be on jury duty again. By the end of day 3 of deliberations in the Holmes trial, the jury had already decided to find the fallen Theranos founder guilty of defrauding investors who had poured millions, hundreds of millions of dollars into the Silicon Valley blood testing startup, according to one juror who spoke with ABC News in an exclusive interview. And yet, the group grappled for several more days on whether to convict or acquit Holmes, who faced 11 counts of fraud on the 3 other counts also related to investors. We were very saddened. We thought we had failed, said the juror, referring to the moment when, hours before the jury announced its verdict Monday, he and fellow jurors sent the court a note that they had reached an impasse on those 3 counts. Judge Davila instructed them to continue deliberating, but by Monday afternoon, and it sounds like they had been deliberating for days and days on this, because they deliberated for 7 days. So on day 3, they were decided, and they went over the holidays for 4 more days to decide or try to decide those counts. And that is tremendously diligent of a jury to do, particularly after they had been on trial or at trial for months. This trial, the jury selection process started in August. So they have been dealing with this for months. So to give that extra time is pretty incredible. And it really does show the diligence of this jury. So I understand there's frustration about the counts, and I think we'll get some clarity on that frustration with the counts relating to the patients. But I really do think that this jury gave a very diligent effort, and I commend that process working and them working that hard, because that is a jury that worked to come to an agreement. So for those of you that have experience with jury duty, you know exactly what it's like sitting and trying to come to agreement with people for days and days and days. It's like a fight with a family member that will just never end. And you're going round and round and you're like, I see it this way. And they're like, I see it this way. And you're like, right. Can we agree to disagree? And that's where they came to. Can we agree to disagree? So let's see. The judge instructed them to continue deliberating, but by Monday afternoon, the 8 men and 4 women maintained they still could not come to a unanimous consensus. At approximately 4 p.m., after 7 days of deliberation spanning 2 weeks, including the breaks for the holidays, the jury convicted Holmes on 4 counts of fraud against investors, found her not guilty on 4 other counts regarding patients who took Theranos blood test, and the mistrial was declared. Everyone spoke their mind, he said, and we were all still exactly where we were when we started, and we had nowhere else to go, nothing else to say. That's why we came in with the verdicts we did. It's tough to convict somebody, especially somebody so likable with such a positive dream. And that is such an interesting statement from a juror. It's interesting to see them say, we did like her. Like, her testifying obviously worked in her benefit, and it's always a gamble, but she testified and still came across as likable, as someone who is likable with a dream to make the world better. And that's fascinating to hear the jury say, because you'll hear some juries say, essentially, no, that person's a criminal. We're done. They need to be away from society. Seeing the jury say, look, we really did like Elizabeth Holmes. We believed in her dream too. And then say, but we still found her guilty of the things we found her guilty of, means they were working past the emotion. And that's fascinating to me. He said he voted guilty on the 3 counts on which the jury could not agree. We respected Elizabeth's belief in her technology and her dream. We thought, quote, she still believes in it, and we still believe she believes it. And in the first podcast episode I did talking about this case, I said that it was going to come down to whether she believed her own technology or her own bullshit, and whether the jury believed that. So if she believes it works, Is she defrauding them? Is there an intent to defraud there if she believes what she's saying? Because if she believes what she's saying, there might not be intent to defraud. They still found intent to defraud. And I think the prosecution did a great job in this case with their kind of theme of, out of time, out of money. And when she ran out of money, she turned essentially to fraud and really hit that theme of, instead of choosing business failure, she chose fraud because she was out of time and out of money. And it's interesting to see that theme of the prosecution seemed to have worked, because even though the jury thought that she believed in her technology and they thought that she did have a positive dream and they found her likable, they still convicted her of a number of counts that have the potential to put her into prison for a substantial amount of time. So Katz, a Daytime Emmy Award-winning TV writer from Aptos, California, who built a camaraderie with his fellow jurors over the 4-month-long trial, often putting puzzles together with them during breaks or watching on as others swapped their turkey, ham, or roast beef sandwiches, said that the decision to convict Holmes on 4 counts hinged on a few key elements, and this I found fascinating. For one, Holmes bore ultimate responsibility for information disseminated to investors. For information to investors, not for information to patients. Katz said, noting that the one-time CEO owned everything. Everything went through her, he said. She had final approval. The jury also found Holmes' 7 days of testimony to be largely non-credible. They liked her, but they thought that she was maybe not being super truthful with them. The 12 members ranked each witness's testimony 1 through 4, 1 being not credible or non-credible, and 4 being the most credible. Holmes scored a 2, he told ABC News. A few government witnesses, on the other hand, including former Theranos lab director Adam Rosendorf, who testified that during the period in which Holmes was raising money from investors, he had apprised her of the dysfunction in the company's clinical lab, had scored as high as a 4. No one scored as low as a 1. Katz also said that early on in their deliberations, the jury decided to acquit Holmes on all 4 counts of fraud against patients because the CEO was 1 step removed from the alleged victims, and thus the jury didn't feel that they were directly defrauded, which is very interesting. So they found that with regard to the patients, because she was talking to doctors, because doctors were talking to the lab, that whatever it was, she was too removed, that she had an intent to defraud patients directly. I imagine that information is going to be key to the prosecution when they go to prosecute her co-defendant and former COO and former boyfriend, Sunny Balwani. They are going to say, how can we show better and explain better that he is not removed from the patient fraud, and they are going to do that better. But because she was acquitted, they don't have a second crack at it with regard to her. They get to take a crack at Sunny Balwani instead. And I imagine they will change some of the way they present that evidence with regard to him, and that he might get convicted of that as the COO being more in touch with the lab. Although the 12 were mostly confined in the jury box in Davila's 5th floor courtroom throughout the trial, they had a bit more freedom to move around in an adjacent courtroom where they deliberated. One juror, who always arrived early, assumed the judge's chair throughout the discussions. So they were in an empty courtroom and somebody was like, I'm sitting up. And in most federal courts, the judge's chair is elevated. So there's the counsel table, and then there's the well in between the counsel table and where the judge sits. And then the judge is elevated up above the rest of the courtroom. I think it's so they can feel like they are up upon high. They can climb up and sit in judgment of anyone below them. But it's also so they can see the whole courtroom and have a good perspective. And then the jury box is like off to the side. It's interesting that there was a juror deliberating just sitting in the judge's chair. Others took seats stationed at the 2 attorney tables. Some choose to sit in a similar jury box to the one they had been seated in during witness testimony, adding that he claimed a first row seat on an audience bench. What's interesting is that they had that much space. In most of the courtrooms I worked in, there was the courtroom, there was the judge's chambers, and then there was a jury room behind the courtroom that had like a conference table and a whiteboard, and they would sit in the conference table and they could bring food in there and kind of have their deliberations where the door was closed, and then the courtroom would keep going with its business. So different than this setup where they had them. And I wonder if they had them in an open courtroom because there's more room for them to social distance because of the vid precautions, and that might be why they chose to do it that way, because of that. So as I'm talking out loud, I'm like, oh, that's probably for social spacing instead of being in like a conference room for 10 hours a day with the door closed. It's probably better. So they go on to say that the first thing the jurors did when they arrived at court on December 20th, the day they began deliberations, was to select a foreman. They nominated juror number 2, who they described as one of the younger members of the group, but was very mature and organized. He said, "I'm not against it." And their vote for a leader was unanimous, which is always good. Your jury starts off getting along and they're like, we can vote for this. They took an anonymous poll to gauge where each one stood on every count leveled against Holmes. This is how I had a number of verdicts come back very, very quickly, because they would pick a 4-person, and sometimes twice that I remember very distinctly, before we even sent back the exhibits, because we were still marking them, they buzzed that they had a verdict because they took that first initial poll and were unanimous. And they're like, so are we done then? And they were. The fastest that has ever happened in one of my cases was 12 minutes. So it's very interesting when they take that initial poll, when they agree all at once, and you're like, oh, and then they just stop deliberating. So then they say that after their first pass, their votes were mixed. They laid out a timeline of events on the chalkboard and then stuck note papers with relevant points of evidence. Despite their disagreement on some elements of the case, the group got along famously. Katz said, adding that he was proud to have worked alongside his peers, many of whom were juggling jobs and family obligations at the same time. On Tuesday afternoon, a day after his role in the rare takedown of a Silicon Valley CEO ended, Katz slumped back in his living room chair. "It was an honor, it was a duty, and I did it, and I'm done." So I think that's let's see, I can take this out of reader mode because there is a photo of him that was shared on this. I just didn't want it to slow down with all the ads. But with that, most juries I see work in a similar way, where they take an initial poll and they use a whiteboard or post-it notes or whatever to lay things out and have conversations. The jurors in the Durst case actually got together for a barbecue and invited the prosecutor from that case to join them. I've heard of juries getting together after jury duty because they get to know each other so well and they share a very common and unique experience. I imagine now with social media, it's even easier for jurors to stay in touch and to support one another after going through such a unique experience, especially with a high profile case. So it's interesting that the juror allowed himself to be photographed and shared some of the things that were kind of mementos from his time on jury duty. So that is the end of that. Our next topic, let's see. Oh, we're going to do the McMichaels sentencing, then we'll get into Britney, then we'll get into the Maxwell mistrial. So that is what they are. That's what we're doing. I have no idea what my husband has cooked. I'm so curious. I'm like the cat, I can smell it and I just don't know what happened. It's going to distract me all night long. Let us get to the McMichaels sentencing. We're going to, and I call it the McMichaels sentencing because it's so strange to me when some cases end up being referred to by the victim's name, some cases end up being referred to by the defendant's name. But with that, I should swoop and then continue to say that. I should swoop and then talk about it. With that, the McMichaels are the individuals that were sentenced in the murder of Ahmaud Arbery. We are going to go through the video of the judge reading out the sentencing, and then I will stop and go through it. I see you guys asking, is the smoke detector gone off? No, I can just smell it. He will never text me back because he never sees this. What is that? It might be the new air fryer. That could be it too. That could be it too. So after we get through our topics, I might ping him and ask, but it could be the new air fryer because we are learning. It was at Costco. It was an impulse. We were supposed to be talking about sentencing, but it might be the new air fryer. That's a very real possibility. Very real possibility. Let us go to this. Let me pause this real quick. Let's go to this video. You should be able to hear it through the through my system. I am still learning all of my new tech, but I am trying to make it so we can listen to videos more easily. And hopefully this will not disappoint us like it has all the times before. Don't let me down. Don't let me down. And we will stop and talk about each sentence as they are read. And again, I've covered briefly the killing of Ahmaud Arbery. It's something I've talked about on a number of occasions, but I am not going to go back through the whole outline of the case. I think most of you are familiar with the case and that the 3 individuals were convicted and all 3 individuals were sentenced today. Gregory McMichael, Travis McMichael, and then their neighbor, Roddy Bryan Jr. So let us go to the judge reading out the sentence, and I will talk about those sentences as we go. If there are sound problems, the mods will let me know. The mods will let me know. Well, no. Let's make this a little bit bigger, and hopefully the sound's on. All right.
That said, with regard to the sentence in this case, as to Travis McMichael, Mr. McMichael, the court sentences you as follows. Count 1, malice murder, life without the possibility of parole. Count 2, felony murder, is vacated by operation of law. Count 3, felony murder, vacated by operation of law. Count 4, felony murder, vacated by operation of law. Count 5, felony murder, vacated by operation of law. Count 6, aggravated assault, merges into count 1. Count 7, aggravated assault. The court sentences the defendant to 20 years consecutive to count 1. Count 8, false imprisonment, merges into count 1. Count 9, attempted false imprisonment, 5 years concurrent to count 7.
So with that, there's a lot that just happened very quickly, right? And with all of that happening very quickly, I'm just going to break it down real quick. I got rid of the judge. Okay, we'll just get rid of the judge for a moment. I'm in charge now, Your Honor. Sorry, Star Wars. With that, the count 1 is the main count, the malice murder, the first degree, kind of depraved murder. That count is life without the possibility of parole, often called LWOP. So the chances of you getting out are 0. You do not get a chance to get parole. It is life without parole. You are going to prison. You are not getting out of prison. That is the end. The rest of your life is now prison. When you heard the judge saying vacated by operation of law, those are lesser included crimes to the main crime. So the judge is not going to sentence on them. They are vacated by operation of law. They will merge. There was one individual, the victim in this case, Ahmaud Arbery. So all of those different counts are different ways to charge the killing of Ahmaud Arbery and the assaults of Ahmaud Arbery leading up to the killing. Because the most serious charge was found, you can't sentence on all of the lesser included charges. So when we talk about lesser included charges, in other cases, they are vacated by operation. You can't be sentenced on a murder and then the other lesser included. So that's what vacated by operation of law means. You can be convicted of all of them, but you can't be sentenced on all of them. Now, if there are things that happen on appeal, you can go back and sentence on those different charges if need be, but they won't be. So sentenced on the main charge to life without parole. Then there was count 6 or 7 that was 20 years consecutive. So that's after the life sentence. This is it's not really a technicality, but it becomes life plus 20. And you will see sentences of life without parole plus more. And when you get to the plus more, no, they're not going to serve it. No, you cannot continue serving after you've served a life sentence. But the reason that you're sentenced on those is not just for reasons of appeal, but also because some of those have mandatory consecutive minimum sentences. And so when he's saying, look, it's 20 consecutive and then 5 years concurrent, the 5 years merges into the 20. So it ends up being life plus 20 years. In practicality, go to prison, never get out of prison is what that sentence is. Let's go on. And I've seen sentences in the life plus hundreds and hundreds of years because all the mandatory minimums stack up consecutive after that, and that can happen. It doesn't I hate to say it doesn't matter, but once you get to the life without parole, it's not as though you get like a 25 to life sentence. You will get 25 years and then be eligible for parole. If you add time consecutive, that 25 can go up to 25, 45, 55, 65, and then you don't get parole until that amount of time has passed. When it's life without the possibility of parole, it doesn't matter that much because you're not going to serve 20 years after you pass. Let us continue to the next sentencing. So, and this is very much what sentencings are like. You will have all of the hearing beforehand, and those are on the internet. If you want to go watch the hearings, you will see the prosecutor make a statement, the defense attorneys make statements, family members make statements, and you can go watch all of those impact statements. But this is, and then the judge's statements leading up to this is just the reading of the sentences. And if you want to see all of those statements, those are available on the internet. We're just going through the sentencing to explain that today, but you can go find all of those. Victim impact statements, the statements of family members of those who have been killed are heart-wrenching. So make sure that if you want to go watch that, do just know it is heart-wrenching to watch those. And it's heart-wrenching being in court, having to sit there and just, you get used to kind of locking it up because it's tremendously raw.
That is life plus 20. Greg McMichael, the court sentences you as follows. Count 1, malice murder. Defendant was found not guilty. Count 2, felony murder. Life without the possibility of parole. Count 3, felony murder. Vacated. When I say vacated, it's vacated by operation of law in all cases. I'm not going to repeat it. Count 4, vacated. Count 5, vacated. Count 6 merges into count 2. Count 7, aggravated assault, 20 years consecutive to count 2. Count 8, 10 years concurrent to count 7. Count 9, 5 years concurrent to count 7. That is life plus 20 years.
So as we talked about, again, that is another life plus 20. And the life plus 20, again, on different counts, because they found him guilty, not of the first degree murder, but of the felony murder. We will do felony murder another day. There is a lot of law. There is a lot of law when it comes to felony murder, but they didn't find him guilty on count 1, but they found him guilty on the subsequent counts. So that is also a count. The felony murder count also has an LWOP option, which is why it's now life without parole on count 2 instead of count 1, and plus the 20 years. So
years. Roddy Bryan, I do want to separate a little bit because the state is making a different recommendation. So the court recognizing that Mr. Bryan's position is different. Again, Mr. Bryan was found not guilty on count 1 and count 2. Court sentences Mr. Bryan to life with the possibility of parole on count 3. Count 4 is vacated. Count 5 is vacated. Count 6, the defendant was found not guilty. Count 7 merges into count 3. The defendant is sentenced to 10 years consecutive to count 3 on count 8 and 5 years concurrent with count 8. Both of those counts, though, will be suspended sentences, which gives Mr. Bryan a life with the possibility of parole sentence.
So I would need to look at what their life with the possibility of parole is, because the judge is clearly separating the person who was not part of the assault, the person who videotaped it, as as a separate sentence. The state gave a separate sentence. I think that on the facts, that's appropriate. And life with the possibility of parole means that he will have to serve some amount. It's normally between 15 and 25, and then will be considered for parole. The judge did not add on to that and could have. The judge could have added that 15 years on top of whatever their minimum is, life with parole, normally in that 15 to 25 range, and could have added another 15 to that and chose not to by suspending the sentence. So in suspending the sentence, he will not have to serve that additional 15 years that you just heard the judge talk about to be eligible for parole.
Those are the sentences.
And that's it. Those are the sentences in the murder of Ahmaud Arbery case. I think that it's appropriate that they treated them separately. It is different. I also think that based on the facts, that those are appropriate sentences. There's a reason that states have life without the possibility of parole. There are some cases where life without the possibility of parole is completely appropriate in my opinion. That might not be everybody's opinion, but when you look at the facts of specific cases, there are some crimes that are horrendous and heinous, and people should be in prison for them. And so that is why there are times when people are like, no, we should get rid of LWOP. And I'm like, and that's LWOP. I realize WOP now has a different connotation this year. It did not when I was still practicing as a prosecutor, but there are some crimes when you look at them, you're like, there is nothing other than prison that needs to be in this individual's future. So that is what that is. So I see the question of what is a suspended sentence. It means they don't have to serve it. The judge is sentencing it on the books, but you don't serve that time. That time is suspended. If something happens on appeal, that sentence can be like activated, but it doesn't need to be. So that's what it is. So 2, life without the possibility of parole, 1, life with parole. I will look at what that minimum is. It's probably in that 15 to 25. So I will look. Some of you, in the chat are saying 30. That wouldn't surprise me. So we will go see. I need to go look at the code, because I was looking at things that the media was reporting on sentencing on other cases, and they are not always right. So I will go pull up the code and take a look at it. I just have not had a chance to do so. So hopefully that makes a little more clear the sentencing of Travis McMichael and Greg McMichael. They are both serving life without parole plus 20. And then the neighbor is serving life with the possibility of parole, which is just a life sentence. And I'm looking at the article from NPR real quick to see if it says what that minimum is, and I'm just not seeing it at first glance. So I will go look up the code and share that with you guys on social when I have that, because I want to know. So that for me, it feels like a just verdict and a just sentence based on the facts. So that's what that is. There's not, I don't really know what else to say other than that was sentencing. If you want to watch the victim impact statements, they are shared on all of the major media sites on YouTube, and you can go look at those. We are going to go to the Britney case. There are some new filings, and we will go. Stephanie was saying, I just now looked up Australia law on this. Turns out we don't have a life without parole, but we can stack life sentences to delay parole. Longest sentence given is apparently 46 years, has been the longest LWOP. I've seen LWOPs that are like life without the possibility of parole plus like 300. We can have some very high cases. So with that, the Ahmaud Arbery case, in homicide cases, it never feels like justice is served. It feels like there's a just verdict and a sentence, but it never like undoes what was done, So let us move on to talk about Britney and what is going on. I don't think it's fuckery, but I've only given it a cursory glance. So we will have to look deeper to see if there is fuckery afoot. Because there might be. Because there might be. So let us go. I mean, I guess I should say before we move on, with the Ahmaud Arbery case, it is done on the homicide case, but there is still cases going on with regard to the initial prosecutor in the case. And I haven't circled back around to that, but will, because I feel like when it comes to prosecution malfeasance, that it's easy to watch a bunch of defense attorneys yell about prosecutors, but I also feel like there is times that I can lend my voice to that conversation as well and say, this is well outside of what prosecutors should be doing. And I hope that that is helpful commentary. Sometimes it gets politicized, which I don't like. Prosecutorial malfeasance shouldn't be politicized because justice should be blind. Prosecutors should be dedicated to doing justice. And sometimes that means not filing a case. Sometimes that means not bringing a conviction. Sometimes that means not bringing a case. Sometimes that means bringing a case when it's not politically expedient. So I think that can help. But I should swoop. We will go talk about Britney. Because it's Britney. Britney is a free. I'm gonna swoop, Emily, swoop, for the love of the swoop. Britney is a free woman living her best free woman life over on Instagram, which go Britney. I'm here for it. I follow her Instagram daily because there's always something new or nude on Britney's Instagram, which I find fascinating. But she's like, I'm free, bitches. And you can almost you can see the difference and the shift in her Instagram account. And I'm here for it. Like, do what you want to do, Britney. Live your best life. I think some of it's just a giant FU to those who controlled her for so long. And I'm here for all of it. I am here for all of it. So let us talk about this joint stipulation. Oh, I'll just pull the one that's signed. Hey, Emily, we don't need to look at both of them. We can look at just the one that's been signed. This order has been signed. It was signed on January 7th. That's today. So let us go on ahead with this. This is a joint stipulation and order to take a hearing off calendar. So a hearing that was set that is not set. These are attorneys for non-parties, TriStar Sports and Entertainment Group, and Robin Greenhill. So we've got some more TriStar stuff to talk about. Let us do that. Non-parties TriStar Sports and Entertainment Group and TriStar employee Robin Greenhill, collectively TriStar, and Britney Spears, collectively the parties, by and through their respective counsel of record, hereby stipulate and agree as follows. The attorneys have agreed to something. Whereas on October 1st, 2021, Spears served subpoenas on both TriStar and Greenhill. Whereas on November 5th, TriStar and Greenhill filed a motion to quash deposition subpoenas or in the alternative for a protective order. Whereas TriStar's motion is presently scheduled to be heard on January 19th at 1:30. Whereas the parties have agreed to take the motion off calendar for January 19th and will contact the court regarding a new hearing date. I think this means they're trying to work it out. It is hereby stipulated and agreed among the parties and respective counsel of record to take the January 19th hearing off calendar at 1:30 for TriStar's motion. That doesn't mean the other motions that are set for that day are coming off calendar. They are not. All the other motions on that day are still on calendar. I believe that the parties, and this is the court's order, proposed order, lined out, signed by the judge. Nothing is below, nothing is above. Those are lined out to make sure that nobody adds anything after the fact. It is really just that I think they're probably trying to work it out. I think that's why this is being taken off calendar. There's no need to hear it. I think they will probably grant a protective order with regard to the deposition subpoena because I can see it being in Britney's best interest if they want a protective order over some of the information, that it's in Britney's best interest to get the information and to move forward and not necessarily have it all be public information. And that's fine. I'm curious, but also the goal is that Britney gets supported and that Britney gets the information she needs, including, will we see TriStar split from James Spears? Will we see TriStar sharing what James has been up to? Will we start seeing Team Con turning on each other? Is it possible? Sure is possible. So this feels like they're trying to work out, they're trying to work something out, and that's why they've moved the hearing date back. Also stated is that the motions taken off calendar, that the briefing deadlines, including Spears' opposition to the reply, be told, which means paused, until the parties, not like for whom the bell tolls, paused, until the parties agree on the court and the court subsequently approves a new date. I think they're trying to work it out. And now I have Metallica stuck in my head. We've run the gamut today from We Don't Talk About Bruno to For Whom the Bell Tolls, Time Marches On. Does Emily listen to all the music? Yes. All of the music. We haven't gotten into singing country yet. I'm sure it'll pop up. Well, it did kind of pop up the other day. I was talking to a friend about the case that we're going to be talking about next. And I was talking about moving to Tennessee and understanding some of country music better, particularly like Garth Brooks, but driving around and seeing license plates. The license plates in Tennessee have the county on them. That's not something that happens in California, but it says what county you're from. There's a coffee county here in Tennessee that I'm like, why didn't we move there? Because my license plate would actually say coffee on it. And I think that's brilliant, but also we love where we live and we're close enough to the airport, like not so close we hear it, but close enough to get there in a relatively sane amount of time, which matters very much to me. And there's also a Grundy County. And so I was driving around and I saw a license plate with Grundy County. I called my BFF from high school who shared the Garth Brooks concerts and the love for Sold by John Michael Montgomery and started yelling the lyrics of that song through the phone at her. And I'm like, Grundy County's in Tennessee. I have learned things. It's right here. And I'm like, hey, pretty baby, won't you give me a sign? I'll do anything to make you mine, oh mine. I'll do your bidding and be at your beck and call. Never seen anyone looking so fine, man. I gotta have her. She's a one of a kind. I'm going once, going twice. Sold. Anyway, we had to diverge for a second to talk about Grundy County. I was fascinated. I love it. I love that it's here. So as we now have run the gamut from Metallica and Spirit Fingers and country music, it's time to move on to everything. Emily, are you procrastinating talking about the Maxwell case? No. Yeah, I hate it. I hate what we're going to talk about. I hate what we're talking about next. Madeline, thank you so much for the super chat. First live I could catch in a while. Appreciate you, Emily. Always look forward to your streams. Thank you so much. And welcome. It's good to see you. We will thank you for the super chat. That is tremendously generous. All right. Let us move on. I love it. Sold to the lady in the second row. She's an 8, she's a 9, she's a 10, I know. She's got ruby red lips, blonde hair, blue eyes, and I'm about to bid my heart goodbye. All right. We're moving on. Chat, y'all are my favorite humans ever, and I just absolutely adore you. We're all just going to put on our rational thinking brains and we're going to talk about this. I hate all of it. We're going to talk about it. Now you know how I feel. We're going to talk about the facts and then I will answer questions. I'm sure the questions are going to be about the fuckery. G-Max was convicted and now that is in jeopardy because of interviews that a juror has been giving. So I think the easiest way to do this is to go through what the government said to the court, what the defense said to the court, what the juror said in the media interviews, and what I think will happen next. I hate it so much. I hate that we're here. Like, it felt like the time we got to the verdicts was like, okay, we're here. There's convictions. We have, the victims have testified. They have dredged up all of the horrible crap that has happened to them. And now that is all in jeopardy. So props to the government for, Emily, don't clip that out of context. Emily, you say that so rarely. Yes. Yes, I do. I'm highly skeptical. Props to the prosecutors in this case for bringing this to the court's attention, because it is the ethical and proper thing to do, and ethics matter. And when you're a prosecutor with the weight of the government behind you, ethics mean the most. So let us just get into the government's notice from January 5th when all hell broke loose. The government has become aware that a juror has given several interviews to press outlets regarding his jury service in this case. Footnote 1. The government is aware of at least 3 interviews at this point, which are available at the following links: independent.co.uk, The Independent, Trent Krim. No, not Trent Krim. thedailymail.co.uk, and Reuters.com. So I will pull these 3 and we will go look at them in a minute. Well, the court instructed jurors that they were free to discuss their jury service with anyone of their choosing. Some of the statements as related in the media merit attention by the court. In particular, the juror has described being a victim of SA. Why are we pulling punches on saying SA? Because YouTube's. And we're not going to get into details of that. So all of you who are like, this could be triggering, there will not be details beyond that. And we will not be getting into details beyond that. So just know that we will not be getting into details beyond that as we talk about it. Assuming the accuracy of the reporting, the juror asserted that he, quote, flew through the prospective juror questionnaire and does not recall being asked whether he had been a victim of SA, but stated that he would have answered honestly. Footnote 2. Footnote 2. See Reuters. And then it's redacted. Here's why I think it's redacted. Let me just tell you what I think. Here's why I think it's redacted. I think it's redacted because the rest of that puts in what the juror said in their juror questionnaire, which is confidential. And I think that the reason that the government brought this to the court's attention is because in the juror questionnaire, he didn't say that he had been a victim of SA. It asks repeatedly in the juror questionnaire, oh, Emily, did you go pull the juror questionnaire? Yeah. I went and pulled the court's proposed questionnaire, and I went and pulled the modifications from the attorneys and went through them. So it's asked multiple times. And I believe that this is redacted because this redaction would have included information from the juror questionnaire. So that is my speculation. That is why I believe that is redacted. But if the juror had answered about that in the juror questionnaire, honestly, none of this would matter. I should go back to just me. None of that would matter. If the juror had disclosed their experiences that they then talk briefly about in their interviews, it wouldn't need to come to the court's attention because the jurors would have been able, or the attorneys would have been able to ask questions of that juror during voir dire. But if that didn't come up if they didn't answer that on the jury verdict forms, then it's a problem. Like a very, 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 very big potential mistrial problem. So that's why this has to be the case that this juror did not disclose it on the jury verdict forms. Because if the juror did disclose it, we wouldn't be here and the government never would have filed this. And there wouldn't be things redacted out of this. And we'll look at the jury forms in a minute. So based on and again, the footnote being at he would have answered honestly, and then the footnote being with the article and what he said, and then this means that is redacted to protect that juror. Based on the foregoing, the government believes that the court should conduct an inquiry. The government proposes that the court schedule a hearing in approximately a month, along with an appropriate schedule for pre-hearing briefing regarding the applicable law and scope of the hearing. The government respectfully submits that any juror investigation should be conducted exclusively under the supervision of the court, meaning the attorneys should not be contacting the juror, which they shouldn't. If the court decides to schedule such a hearing, the government respectfully suggests that the court's staff promptly contact the juror to notify him of the hearing and inquire whether he would like counsel to be appointed in connection with it. The government reached out to defense counsel last night regarding the juror's statements, but defense counsel has not yet responded. Thus, the government is not aware of the defense position on the issue. On this issue. Let's talk about the defense position. The defensive position is, are you fucking kidding me? This case needs to be dismissed and a mistrial needs to be declared. So let's get to the defense position and what they said. Dear Judge Nathan, we write concerning an issue of pressing importance. It has come to the attention of the defense that one of the 12 jurors in the case, the juror, we now know it's juror number 50, has been giving oral and videotaped interviews to various members of the press concerning the jury deliberations. These interviews have been publicly reported in several media outlets. Footnote 1. See, they were all believable. Maxwell juror says jury was convinced by accusers' accounts of a pattern of abuse. The Independent. G-Max was a predator as guilty as Epstein. Maxwell, oh, well, we've said his name. We're out now. Maxwell juror describes the moment he, quote, locked eyes with sex trafficker. Now we're just going to say all the words. Screw it. With sex trafficker, and reveals his own abuse ordeal, available at the Daily Mail. And some Maxwell jurors initially doubted accusers, juror says from Reuters. Does the footnote continue? No, but there's another one. So, among other things, the juror told reporters that he disclosed to the other members of the jury during deliberations that he was a victim of SA, and further described his memory of those events. We're not going to get into detail on those. And it doesn't in the interviews either, which is appropriate. According to the juror, his disclosure influenced the deliberations and convinced other members of the jury to convict Miss Maxwell. Remember that. Just remember that. Remember that. There is then a redacted bit. I imagine the redacted bit. This is Emily's speculation. Juror number 50 on his questionnaire did not answer these questions about this and did not disclose it. And this is what that juror said. And that juror said that that did not happen. Things the juror said. My guess. We've talked about Rule 33. Rule 33. We've talked about Rule 33 before. When it came to the Jen Shaw Hulu special of it all, there was a Rule 33 motion and the court was like, yeet. Your Hulu doc concerns me not. We will ask a juror. But the grounds for new trial here are going to be that the juror did not disclose. Should the defense prevail on this motion, we believe that the law and the facts are clearly on our side. I don't disagree with the defense in this point. It would render all other post-trial motions moot. We'll talk about what the judge did next and why I think that this is leaning very, very heavily towards a mistrial. GMAX should not have to expend precious time and resources briefing other motions when this motion can and should be dispositive. Dispositive means everything else would be rendered moot by the fact that this verdict would be thrown out. It would be yeeted, and a mistrial would be declared, and a new trial would be set. Accordingly, the defense respectfully requests that the court set a briefing schedule for this motion alone and defer setting a briefing schedule for any other post-trial motions. Again, those will not be relevant if this is granted. Let's talk about what the court did. The court did exactly what the defense asked, and they should. It's totally appropriate. Nicole, thank you. I'm sure if tech goes in and checks, just submit it for review. I'm sure we're already in the no-no zone. Thank you, Amy. Appreciate it, lady. So let's see what the court did. This is also on the 5th. This is how fast the court moved. This is how fast the court moved. The court was like, yeah, this is a problem. So the court, this all happened on the 5th. And the court responded saying, the court is in receipt of the parties' letters, docket numbers. The court hereby sets the following briefing schedule. I think I mistyped this on Twitter, but Twitter doesn't let you edit shit. So I think I put the 12th instead of the 19th. Why is everything happening on January 19th? All of the things, they're like, whatever, fuck it, set everything in the world for Wednesday. The defense motion is due January 19th, and that's going to be their formal motion for new trial. The government response is due February 2nd. The defense reply is due February 9th. The parties' briefing should address whether an inquiry is permitted and or required, if so, the nature of the inquiry. Although the court reserves discussion on whether an inquiry of any kind is warranted, the court grants the government's request to offer court-appointed counsel to the juror in issue. Subject to the juror's right to decline court-appointed counsel, the court will appoint the on-duty CJA counsel to represent the juror. If counsel for the juror wishes to be heard on the issue of appropriateness of an inquiry, briefing by the juror's counsel may be filed by January 26th. The court will not adjourn post-trial briefing on other issues as requested by the defense, but sets the following schedule for any other post-verdict motion by the defense, and then set motions into February. So the court is still anticipating other motions because the government's response is due February 2nd and set the other motions for February 4th. I wonder if that will change. But it indicates to me that the court also believes that this is dispositive. Here's what the court setting a inquiry says to me. It says to me that the juror did not disclose this. This is, again, me reading into what I'm presented. This indicates to me that the juror did not disclose this. If the juror had adequately disclosed to the court's liking in their verdict or their jury questionnaire form, the court wouldn't be setting a briefing schedule and having everyone brief the issue. The court would have said, you all had the opportunity to inquire. The juror made it clear we're not wasting court time doing this briefing. And this is not a shy judge who's just going to be like, go ahead and brief me. The reason there's a briefing schedule is because this is a gigantic freaking problem. I don't know how we get around a mistrial at this point. So let us go to the media articles and then we'll go to the questionnaire. And I feel like we might need to be in the red. And I saw you guys request the red, but I've been enjoying the lights changing in the background because I figured out how to do that. And I've been enjoying the vibes, but I feel like the vibes right now are red, right? I feel like the vibes are red. So with that, I will give the following disclaimer. We are going to DEFCON Red. But with that, I will be playing the DEFCON Red bumper. It is flashy. It will flash. If you are flash sensitive, the flash will be done when the music is over. So either look away or close the screen or minimize the screen, but it will flash for the few seconds until the music is over. So that is my flash warning for all of you that I will always give. But we love this bumper so much. So flash warning, it is flashy, and we're going to get to we're gonna just get to red. Because at this point, this conviction not sticking is it just is. What did I say I was going to do next? I said we were going to go to the media. Let's go to the articles. Let's see what Trent Krim from The Independent had to say. Not Trent Krim. Everyone who has not watched Ted Lasso is like, why does she think she's funny? Look, because we've got to find humor somewhere, because this is just making me angry. I'm just angry. I'm angry at this entire story. I am angry. The amount of work a trial like this takes for the prosecution, for the defense, for the court to get to verdict during a pandemic with the victims coming in and testifying to get there and then have it all tossed out is just it's just so disheartening. Thank you, Matt Bond. I can't believe the juror would put fellow victims through a retrial. Agreed. I don't think this juror saw it that way. I have to wonder whether the juror was paid to tell the media to kill the trial. Here's the thing, though. I've seen that, and we're going to address his statements in a second. I've seen that speculated on the internet widely. But if you're going to put a juror in to mess up a trial, why would it be someone who sways them towards guilty only to mistry it and retry it? Because if there's a conviction and it's tossed, you just retry it. If there is a acquittal, there's nothing that can be done. So on the charge that there's an acquittal for, an NG, nothing can be done. Double jeopardy attaches, you can't touch it. So if you're going to really mess with a jury, you mess with a jury by going NG, because then even if it comes out that there was malfeasance, there's nothing that can be done because the Constitution blocks it. So it doesn't make sense to me that you would push a jury towards guilt and then mistry it and then have to do it again. It doesn't make like logical sense to me. Maxwell juror opens up to the Independent. This verdict is for all the victims. Well, no, not if they have to go through this again. And also, that's not what verdicts are for. I mean, verdicts are I will soapbox on that later. A juror in the Maxwell trafficking trial has told the Independent that he voted to find Maxwell guilty of the majority of the charges against her because he believed the stories told by the victims. Well, which is a proper basis to find someone guilty. I believe the victims. I believe she did this. And because he believed the pattern of abuse they all described. Scotty David, who wishes to be identified by his first and middle name, I'm sure the internet has already discovered everything in the world about him, told the Independent in his first media interview. Why the Independent, though? Just curious. Well, I guess there's an intense media interest across the pond as well because she is a dual citizen. I get that. But also it was interesting. In his first media interview that he believed all of the victims who testified against Maxwell in her trafficking trial that took place in Lower Manhattan over the past 4 weeks. 4 weeks. All of the accusers corroborated each other and were backed up by other evidence, he said. David said he's proud to be part of holding Maxwell accountable for her crimes. The verdict is for all victims, he told the Independent. For those who testified, for those who came forward, and for those who haven't come forward, I'm glad that Maxwell has been held accountable until it's mistrialed. This verdict shows that you can be found guilty no matter what your status. David told the Independent that he found all of the accusers who testified to be believable and credible despite the defense's many attacks to their credibility and their attempts to poke holes in their memory. They were all believable. Nothing they said felt to me like a lie. David knows that sometimes you can misremember small details of traumatic memories without ever doubting the core of the memory. He knows that because he himself is a survivor of SA. I know what happened when I was abused. I remember the color of the carpet, the walls. Some of it can be replayed like a video, he explained this to the jury. But I can't remember all the details. There are some things that run together. So he knew that some misremembered details doesn't mean that the memory itself didn't happen. There were also questions from the jury about why the girls didn't come forward earlier. David said he knows what that's like too. I didn't disclose my abuse until I was in high school, he said. The jury room went dead silent when he shared his story, he told the Independent. He believes that this helped the jury understand that it's possible that these women were telling the truth. And that is exactly why there will probably be a mistrial, because the defense would have had the opportunity to question him about that and decide if he could be fair in this trial or if his experience could sway the jury in deliberation. And the defense and the prosecution have a right to inquire, but if he doesn't disclose it, they can't inquire. And now that it's come out, there's no putting this shit back in the horse in any way, shape, or form. He went on to say that we cannot judge what they did or didn't do afterwards. He said, it doesn't change that it happened. And while I don't disagree with him not disclosing that, or apparently not disclosing that, is the problem here. David felt that the defense were continually attacking the accusers on the stand and said that those attempts did little to change his mind. At one point, the accuser, testifying under the name Carolyn, threw her binder of evidence down beside her because she was so distressed by the questioning she was being subjected to. It just made me feel more compassion for her, which is also feedback that the defense will now take in the second trial and not attack the victims so hard. The juror said that ultimately the jury found that the victims were credible. The defense team focused strongly on its memory expert, Professor Elizabeth Loftus. Loftus testified about experiments that had been conducted in which researchers had successfully implanted a false memory in the mind of research subjects. In one study, the researchers were able to change a detail of a memory about witnessing a car accident. They were able to convince participants that the scene featured a stop sign rather than a yield sign. But that didn't sway the jury either. None of that relates to traumatic memory, he said. Loftus said herself that she had never conducted a study on whether those tactics would work with memories of sexual abuse. Since the trial, there has been speculation that the fact that a juror had been a victim of sexual abuse could be used by Maxwell as grounds for appeal. Speaking separately to Mail Online, David said that he could not remember the details of the 50 question pre-trial questionnaire that each potential juror was asked about whether they were a victim of abuse or a relative of or a friend of a victim, but he felt he answered all the questions honestly. He told The Independent that the accuser's testimony was corroborated by a significant amount of evidence. He specifically mentioned Kate, an accuser who testified but was not allowed to be considered for the actual charges because she was over the age of consent in the UK when she was abused, and said her testimony powerfully corroborated the other accusers' stories. She said she was able to show that this was a pattern. We knew that she could use her testimony. Couldn't use her testimony to convict Maxwell, but she showed the pattern of how these girls were groomed. She showed us the pattern that happened to all of these girls. It was about confusing their boundaries. For Jane, it started with seeing Maxwell topless. For Annie, it started with Maxwell showing her how to give Epstein a foot massage. The pattern is that G-Max talks to you like she's also a teenager, then moves into massage, then tries to make you feel comfortable to see what they can get away with. What she did was wrong. Well, what she did is the textbook definition of grooming. Annie Farmer's story was backed up by her teenage diary as well as her high school boyfriend, and that was very important to the jury, he said. Carolyn's story was backed up by Sean, her ex-boyfriend, who testified that he used to drive her to Epstein's Palm Beach mansion. Jane's story was backed up by her high school boyfriend, who remembered being told about Epstein when they were younger. The accuser's stories were backed up by flight logs. The stories were backed up by Maxwell's little black book. David said the little black book also gave jurors clues about how Maxwell and Epstein had evaded accountability in the past. There were the names of several Palm Beach police officers listed on a first name basis in that book, he said. Those girls' names and phone numbers were listed next to the words mom and dad. He said professional masseuses do not need their parents with them. Many speculated that the jury chose to acquit Maxwell on count 2 because that count related solely to Jane and that Jane was less credible. David told The Independent, we simply didn't see enough direct evidence to convict on count 2. It wasn't about not believing Jane. So the statements that he made that are going to be the most problematic in this interview is that his own story is what he told to the jurors to sway them towards convicting, that his own story bolstered the credibility of the witnesses, and that is going to be a very big problem, and I don't know how the court is going to tackle that. So I'm just going to answer a few of the super chats, and then I'm going to talk about the jury questionnaire and then get into questions. I know we're at an hour and 43 minutes. We'll go a little bit over because I want to get to questions for sure. What if he is a lying liar who likes to tell stories? Could he have just made it all up to feel important? It doesn't matter if he used that story to sway the jury. Whatever he experienced or didn't experience, whatever he told the jury, if he didn't disclose it and was questioned on it and then used it to sway the jury and it was in the jury questionnaire, it doesn't matter per se if it's true or not. What matters is how it was used. Hopefully that answers that. Does juror 50 have charges coming if they didn't disclose? Appreciate what you're doing. I will get to that during questions because I want to look at the end of the juror questionnaire together. Could it be contempt of court? Possibly, but it really, really is heavily dependent on the circumstance. So, and the circumstance is going to be that this could be mistrialed. So I see a number of questions about the legal recourse, and we will get to that. So there are a few other news articles. I will link all the articles below that are in this filing if that's helpful, from the Independent and the Daily Mail. The Daily Mail always kind of crashes. We're just going to go through the headlines of the Daily Mail. It always has so much going on that it makes it very hard to play. It slows everything down. Let's see what we can get. All right. This is the juror says evidence convinced panel she was a predator. The juror in the trial has revealed how he viewed her as a predator, describing the moment he locked eyes with G-Max and revealed his own essay to the jury. Scotty David said he helped other members of the jury understand things from a victim's point of view and explained how you can't remember the details of traumatic memories. This was a crucial line of attack by Maxwell's lawyers, who called a false memory expert witness. David also claimed that 5 guilty verdicts returned, possibly condemning Maxwell to spend the rest of her life beyond bars, were for all victims. Legal experts say that if Davis failed to disclose his past experiences before the jury deliberations, Maxwell could have grounds to claim a mistrial. Yep. Agreed. 10-10 agree. However, a question of whether the potential juror was a victim or a relative of a victim was asked in the 50-question survey completed by each juror ahead. Yes, it was. Because I pulled them. He said he firmly believed that she was innocent until proven guilty. That's not the issue. Bias is not the issue. Failure to disclose is the issue. George, what are you doing? Those are my almonds. You never come up to the desk when I'm streaming. Do you want to say hi? Oh, he's like, the hell I don't. I don't want to say how. He was like, whoop, whoop, whoop. George, you never come say hi. Come on. George. He is literally just out of arm's reach. Do you want to come say hi? No? You're like, I'm not having any of it. No, maybe. Hi, buddy. He's like, nope, not at all. Well, maybe he'll jump back up with Fred. Me wanting to show off George. George, no, never gonna happen. Never going to happen. Instead, he's going to mess with the closet. David said he went firmly into trial believing innocent until proven guilty. That's not going to be the issue here. But he said, after all I've learned, she's just as guilty as he is. I don't want to call her a monster, but predator is the right word. She knew what was happening. She knew what he was doing. She allowed it to happen. She participated in getting those girls comfortable. I mean, yes, that seems to be what the evidence showed. But the problem is the jury questionnaire. And the jury questionnaire asks, so we're going to look at what the jury questionnaire, we're just facts. We're going to look at the court's proposed jury questionnaire. There are amendments that were made to this. There were some languaging changes and some numbering changes, but the final one wasn't public or that I could find. But it wouldn't have changed that much. So we're going to go through the instruction sheet. So it gave them all of the information, sworn to give true and complete answers to all questions. So for all of you asking what could happen, this is a sworn declaration. So if it is proven that someone lied on a sworn declaration, then that can be contempt of court. That can also be perjury. Will they choose to prosecute a juror or put a juror like in jail for contempt of court? It's unlikely, but that does not happen. That does not necessarily happen, I guess I should say. Do not discuss your questions and answers or the case with anyone now or until further instruction by the court. You should not discuss your answers or questions with fellow jurors. But more broadly, do not discuss the case with anyone, including the lawyers, except in the presence of the court, your fellow jurors, family, friends, or anyone else. Do not communicate about the case, including telephone, email, or social media app or website, such as Facebook, or any communications app, such as Twitter. You must also avoid reading or hearing about the case or anyone participating in the case in newspapers, magazines, radio, television, or on the internet. Do not do your own research. Summary of the case. The defendant is Maxwell, been charged in an indictment. They go through the counts. They go through a rough statement of facts. The attorneys would have had input and modify this. They give the schedule for the court. And then they go through ability to serve. Do you have time to do it? Can you not? Unmovable commitments. Do you have any international travel plans? It's like it's the middle of a panini, so maybe not. Serious hardship, personal commitments. Please explain. Medical, physical, mental condition or illness that makes you unable to serve. Please describe. Taking any medication which would prevent you from giving full attention. Please describe. Religious, philosophical, or other beliefs. Please describe. Basic legal principles. The jury sits in judgment of the facts. Can you do that? Presumed innocent. Can you do that? Absolute right to testify or not to testify. A juror can't hold it against them. Can you put that aside if a defendant doesn't testify? Required by law to make their decision based solely on the evidence, not based on conjecture or suspicion, bias, sympathy, or prejudice. Punishment goes to the court. Let's see. You can't do any searches. You may hear testimony from expert witnesses. Can you do that? Avoid media, prior jury service, experience as a witness, witness or plaintiff or defendant. Is there anything about that experience? Witness or involved in a federal case. Let's see. Subpoena for an investigation, experience that would prevent you from acting. Have you or a close friend or relative been arrested or charged with a crime? Would that impact you? Have you, close relative or close friend, been subject to an investigation by a grand jury, state or federal, or other investigation? Please describe. Relatives or close friends ever been a victim of a crime? So that's one, because what's being described is a crime. So that's a general question about it. Is there anything about that experience that would prevent you from acting as a fair and impartial juror? Yes, no, please explain. Have you, your members, friends been, or individuals in the course of their business affairs ever been a party to a legal action or dispute within the U.S., dealing with the U.S. Attorney's Office, NYPD, FBI? Please explain. Dispute concerning money you owe the government? Please explain. Relationships with view of government and defense and others. And that literally goes through that. Let's see. We're going to keep going. That's about NYPD. That's about the U.S. Attorney's Office. Do you know any of these people? Personal relationship with case participants. Like, do you know these people? Do you have a friend that knows these people? Do you have a friend who personally knows any of these additional people? Like, do you know these witnesses? Do you know these individuals? Please explain. Knowledge of case and people. And this is asking, this case has been widely reported in the national and local media. There's nothing wrong with having heard something about the case. It's important to answer the following questions truthfully. Before today, have you read, seen, or heard anything about GMAX? Please tell us. If you're unsure, tell us. Have you personally formed an opinion about their innocence or guilt? Tell us. Based on anything you've read or heard, including anything about the criminal charges, have you formed opinions? That's another way of asking that it can come up. You've heard about the charges. Do you have an opinion? If yes or unsure, please explain. Before today, have you heard or seen anything about Epstein? If unsure, please state. Have you verbally stated or posted your opinion on social media or online about either? Based on anything that you've read, seen, or heard about Epstein, have you formed any opinions about him? Explain. If you've heard about Epstein, do you think Maxwell's alleged association will make it difficult for you to be fair? Please explain. Based on anything you've read or seen about her or the charges brought about her, would you be able to follow the court's instruction to put that information out of your mind? So again, do you know about these cases? Do you know about the charges? Oh, well, these charges are similar to something that happened to me. It could come up there too. Nature of charges. This again is an opportunity for it to come up. During the trial, you'll hear evidence of alleged sexual sex crimes against underage girls. Some of the evidence in this case will involve suggestive or explicit content or conduct. Is there anything about the nature of this case and the accusation as summarized at the beginning of this case that might make it difficult for you to be fair and impartial? So again, it could come up there too. Do you have any specific views or feelings concerning laws regarding the age at which individuals can or cannot consent to sexual activity or with other individuals that would affect your ability to serve? Do you have any opinion about the enforcement of federal sex trafficking laws or the federal laws concerning sex crimes against minors that might prevent you from being fair and impartial? Have you or a family member ever supported, lobbied, petitioned, protested, or worked in any other manner for or against the laws, regulations, or organizations related to sex trafficking, sex crimes against minors, sex abuse, or sexual harassment? Please explain. Further, please explain. Witnesses in this case may include law enforcement. Can you listen to law enforcement? Have you or a friend or family member ever been the victim of sexual harassment, sexual abuse, or sexual assault? This includes actual or attempted or other unwanted advance, including by a stranger, acquaintance, supervisor, teacher, or family member. Without listing names, please explain and then talk about that answer. So it's a direct question, but there are other questions that are not direct that would also get to the same thing. Have you, a friend or family member, ever been accused of the things listed above, not been a victim of? Please explain. Is there any other experience that you or anyone close to you has had that may affect your ability to serve fairly? Do you wish to participate in answers? And then this is the declaration. This is the sworn under penalty of perjury declaration. I, juror number blank, declare under penalty of perjury that the foregoing answers set forth in this questionnaire are true and correct to the best of my knowledge and belief. I have not discussed my answers with others, received assistance in completing this. Do not write your name. Please sign using your juror number. And then use this to furnish any answers. There's plenty of room to answer. It's not like you're going to run out of pages to talk about it. So there are multiple opportunities in that questionnaire for it to come up. And the questionnaire isn't where it stops. There's also in-person voir dire, face-to-face, asking questions about this. And it never came up. I'm sure the defense and the government are going to be pulling juror number 50's voir dire transcript. So, in sum, I will on the information that we have tonight, I will be very surprised if a mistrial is not granted, and I'm very disappointed in that answer, and I do not like that. But also that is the appropriate legal analysis in this circumstance, which makes a retrial harder. Because now you've got previous testimony with victims who already have older crimes and difficult memories, who've had difficult cross-examinations. And now there's a transcript of everything they said, which means it's going to double the amount of time they're on the stand testifying next time. But legally, I don't know how a court, given this evidence, and this is not knowing what that juror said, but knowing that all of that information is redacted, and the government brought it to the court's attention, which means they think it's bad. The court set a briefing schedule, which means they think it's bad. And the defense is asking for a mistrial with quite a lot redacted. If the information in the juror questionnaire that we just went over was indicating that that juror had the experiences that that juror is now retelling in the media, this wouldn't be an issue. The only reason this is an issue is because of my presumption that that was not disclosed. Otherwise, it's like, okay, well, we knew all that, and we questioned the juror about that. The reality is, if they'd questioned the juror about that, and that had been their experience, the defense would have removed them either for cause or using one of their peremptory strikes. And not being given the opportunity to do that means that the defendant didn't have the opportunity for a fair and impartial jury, because I didn't have the opportunity to question that juror on that because the juror didn't disclose it. Oi. Just oi. Oi. But with that, I'm sure you have questions. I have questions. I have feelings and I have questions on this one. So let's have our feelings and our questions all together, shall we? I'm going to try to get to some of the super chats that I'd missed and questions that are not super chats. I always try to leave time to do both. To everyone that's still watching, I don't think I've said this in the 2 hours I've been live. Go ahead and do the likey, subscribey things. Look, we're at like 192. And it's January and everything slows down. But I would love to get to 200K. It's just one of those, it would be lovely. And I think I promised that I would live stream in like a unicorn onesie. So, and I think oil slick is the color we decided for 200K. And that would be fun too. So let's just like and subscribe. There's like almost 4,000 of you in here. We Chic said, thanks, love the lives, learning about the law and laughing at the tangents. There will always be tangents. There will always be tangents. There will always be tangents. With all this in the press, doesn't that corrupt possible evidence and future testimony? Acrylic painting with Julie. It causes problems for future juries and finding future juries. And it also causes the problems I talked about with now there are transcripts. So not only will the victims be confronted with their previous testimony and previous statements, it will just draw everything out more. So I hate all of this. I really don't like this at all. But also I don't see any other possibility. And I've asked other prosecutors, I'm like, what do you see? And they're like, this is awful. I'm like, it's all, I don't see any other, I don't see how the judge legally could get around granting a mistrial. The judge is going to have to inquire of this juror, look at the transcript, look at the jury questionnaire, and without more, I just don't know. I just don't know. I don't know how they get around not finding a mistrial. The Texas Phoenix, off topic, but what does it mean when an attorney has been found ineffective as counsel for the attorney and the client? I want to say the case law was Strickland, but I'm not sure what the order said. Ineffective assistance of counsel is a specific finding that something that the lawyer did within the context of the case was not appropriate. And that meant the defendant did not have an effective counsel. And that can also be grounds for a mistrial and for other motions. I don't remember the Strickland case off the top of my head, but I am not a girl that remembers case law off the top of my head. I remember stories and facts very well. Do I remember cases by name? Not always. So that is what ineffective assistance of counsel means. What can it mean for the attorney? It depends on the circumstance. It depends on where they're located. What it means for the client is that generally something will be overturned because the attorney didn't do something, didn't advise of something, didn't object to something, didn't make a motion for something. So that is it. Yes, that is it. So all of this, I need to pull up the super chats that I missed. I feel you guys are like, I'm bummed. I know I'm bummed. A lot of people are asking if money's involved. However, there's no benefit. Like this is going to end up costing Maxwell the cost of another trial, potentially hundreds of thousands of dollars. And they can convict her again on everything. I mean, maybe it makes it harder to convict her, but if you're going to pay someone on a jury, why not pay them to swing it to NG? Like, I just wonder if this is, I don't know, somebody who really wanted the gold star, who really wanted to be like, I helped convict this person. I did this. I need the recognition. I was a part of it. I was a inextricable part of it. This was me. I did this. I told the other jurors, no, those women are credible. This was my experience. I told them that. I did this. And I want the recognition for doing this. But in that, it can undo it because it seems that that wasn't disclosed. I just. It just makes me so frustrated. Question, could Maxwell plea if there's a mistrial or has that opportunity passed? Oh, there could be, but why would you at this point? If I'm the defense attorney, I'll have to ask Natalie lawyer chick what she thinks, but putting on my defense attorney cap, if I heard, and it always depends. It depends on what comes up from the other jurors or from this juror when they are questioned. But it sounds like there were a number of individuals that questioned the veracity of the victims. Knowing that the jurors were struggling with whether the victims were truthful because of their memory, I think you would lean into that as a defense team in the next trial and be like, look, we had a number of them. We got an NG on one count. We're going to keep chipping away, because if the jury can't come to a unanimous decision next time because there isn't a juror saying, no, this is why I believe them, this was my experience. If that doesn't happen, do you end up with a deadlocked jury? And if you end up with a deadlocked jury, do you go again? And you can. If the jury deadlocks, they could try it again. If this gets mistrialed and a jury deadlocks and mistrials, they can go again. It can just take years and years and years. And we know she's staying in custody the whole time. So it's not as if she's going to get out of custody because of this. But it makes it harder and harder to convict on retrials. So, I don't like it. I have cursey words, lots of cursey words. I have cursey words too. Lots and lots. And I can't, I need more information about whether this was like just hubris or arrogance and just wanting that gold star, wanting to share, feeling like you'd done your civic duty and wanting to share about it. The problem is you got to be real quick knowing what you said in that questionnaire. But I don't think that, your legal muggle would know how impactful and what a big problem this could be, because how would you? Question, if the juror had done the interview a few years after the trial, would it have still mattered? Yes, it would have still mattered. If they had put out a book 3 years from now, it still would have mattered. I don't know if they're allowed to. It depends on what the ruling of the court is. They might not be allowed to financially benefit from their service, but it depends. It depends. Question, will anyone investigate the juror's intentions, contacts to see if he was influenced in any way? Possibly when they do an inquiry. I mean, it's possible. It is possible. Does any state in the US limit the amount of time someone can be in prison? In Brazil, the maximum one can get is 40 years, even if they are sentenced to much more. That's really interesting, Pedro. I did not know that. And no, I don't know of any state in the US that limits the amount of time people can be in prison, whether that is a big conversation about the prison and the industrial kind of prison system in the US. But no, there are plenty of people serving life without parole that will just be in prison for the rest of their lives. So no, there is not a top end max that people can serve. So no. Sarah asked, is it possible he lied simply because he wanted to hear the evidence? I'm so sad he tanked the whole verdict. It's possible that he lied because he wanted to get on the jury to convict her. That's very possible, because he did seem to be leaning towards conviction. It's possible that he's like, well, we'll just downplay this a little bit because fuck that chick. Which is possible. We don't know, but it's possible. Especially based on him being like, no, I locked eyes with her. She's a monster. Well, monster is too strong. She's a predator. It could be that and it's not unheard of that jurors want to be on high profile cases because they have a feeling about the case. With not disclosing it though, then it can't be asked about. And this came up in the Chauvin case a little bit too, with a juror who social media posts came up after the trial and whether those were disclosed or not disclosed and whether it would have mattered in that case or not. But these things can be very big problems, and you have to disclose even more than you think you should on jury duty. Otherwise, any conviction that is rendered can be undone, because the constitutional rights of the defendant are are absolutely or should be inassailable. Question, sidebar, who won Mario Party? T. Did they rightly gloat about it? Always. Which is acceptable when a player wins. T always wins. We've started doing a few of the, hold on, we need lip. Don't have the lip gloss I'm looking for. T1, T always wins Mario Party. I have not played a game with him where he hasn't won yet. It might happen in the future, but it has not happened yet. I don't even think he was trying to win the last game and he won. But with that, we've been playing the collaborative stuff. We've been going through the river rafting, and that's been really, really fun. So, yep. Trisha Lynn said, question, I thought it was Galaxy hair and then oil slick. Oh, it might have been Galaxy first, then oil slick. It might have been. I'll have to try to remember which one it was, or I'll just put up a poll for all the members and we'll pick a color. Paradoxically Sweet said, I just found out that Rebel Wilson graduated from law school. Just wanted to share with my fellow law nerds. That's incredible. I want Rebel Wilson to be a lawyer. Can you imagine? I think it would be great. I want that. I want to see, but which country did Rebel Wilson graduate from law school in? I guess that's my first question. Question, are questionnaires state dependent? I don't remember filling one out in 1999, but I do remember voir dire. Laura S., questionnaires are not state dependent. They are very heavily case dependent. In longer voir dire processes, in high profile cases, in very complex cases, in very long trials, they will choose to use a questionnaire to like yeet people before they even come in. So they are common in complex, high profile, and long cases. They are not common in kind of run of the mill, this is going to take a week, come on in and just do voir dire cases. So case dependent, not state dependent. Question, does this mean Maxwell will be free? No, it does not mean that. This is a don't pass go, do not collect $200. She will stay in jail and be retried. It means she won't be sentenced. It means this won't be done. It means that you'll just like, I don't know, just start all over again. They will literally start with pretrial motions all over again. So it just goes back to the beginning, which is awful because all of the witnesses have to come back again. And if something happens to one of the witnesses, I mean, if something happens, it can get more and more complex to retry people the longer and longer and longer it goes. But what can happen is if Maxwell keeps pushing this case out, you can get so far in time that you're going to find a jury that's like, I mean, I don't believe that you remember that stuff from, 1990, whatever, because some of these actions happened in the 90s. So I just, when there's a mistrial, will Maxwell be released until it's refiled? No, and they will have the refile ready. They'll just be like, okay, here's the indictment. It'll be without the count that she was found not guilty of. They can't retry that one. It'll be all the other counts, and they'll just renumber them. And she will still also be in because she's still pending trial on the perjury counts that are part of this indictment that she hasn't been tried on yet. So she's still pending trial on other counts. So no, she will not be out. I would be shocked. But could this juror face some consequences? Possibly. This is for your YouTube suppression fund. I just made that up. Well, thank you, Angel Wood. I appreciate it. We will take it. It'll go directly to the documents fund and the Paw Nerds emotional support fund. Pam Norris said there has to be a mistrial. This is very unfair to the defense. I mean, I don't see any other option at this point. Unless something changes. I don't see any other options at this point. So, question, did you ever have something like this happen in a trial with a juror? Not like this, but I didn't have jurors talking to the media afterwards. I had a juror try to ask me out on a date in the middle of trial, and the juror had to be excused, but it hadn't become an issue where it was mistried. I've had jury panels dismissed before we've seated them because of stuff that's gone on with jurors. I've had jurors talk to me after cases, but never where it's been anything like, oh, weird, we have to report that to the judge. But also very much did not do high profile cases. So, and that was, I mean, would that have happened down the road in my career? Possibly, but I really didn't want it to be. I did not want to do high profile cases. Funny where we are now. It's like, no, I'd rather talk about other people doing it on the internet. But no, I did not want to do high profile cases. They are giantly stressful and they take up your entire life. And when your entire life is living in the evidence of cases like this, it skews your entire perception of the world. And that was a lot. Question, is this the worst example of a juror causing a mistrial? Has something like this happened in the past, or is this really rare? I'm sure there have been things that are similar where jurors have said stuff after trial that have come back. I can't think of any off the top of my head. I'm sure there are examples, but this is bad. So, and again, there are so many trials. And there are local courts too. There's stuff that's not on a national stage where somebody says something to the local media in their hometown, and then there's a problem that we would never even hear about. It does happen. And that's why there's procedures for it, because it does happen. Hello, Miss Opinionated. Happy New Year. Why do I fill out a jury questionnaire? Why can't the lawyers ask us at the courthouse? That form was way too long. Oh, that form was completely appropriate because it will weed out the jurors before, like jurors who had heard about the case substantially won't even have to come to the courthouse, particularly during COVID, not having to bring 300 jurors in and sit around and wait while they question them makes sense. This way they can weed out the jurors that can never sit because of exposure to the case, narrow down the field of just jurors that are eligible, time eligible, and haven't heard of the case, and just question the jurors that actually can serve on the case. If it's a month-long trial and somebody's like, no, I just had surgery, why bring them into the courthouse and make them sit there when the questionnaire says, no, I can't sit on this case? So I think the questionnaires in this case are totally appropriate. And we will see questionnaires in a lot of other cases. There were questionnaires in the Elizabeth Holmes case as well, just to narrow down the pool. Hopefully that answers that. So it makes sense. Yes, she will stay in jail for the new trial. So if she didn't get out pending this trial, she's not getting out pending the next one. Bethany said, what if juror number 50 didn't actually tell the story in deliberation? Can the other jurors testify to this? Yes, they can. And will the judge question any other the jurors? Possibly. It's possible that the other jurors will come in. Oh, I got into the media and forgot to share the other thing. The juror now has a lawyer. Sorry. Joycey, this is a full like, tell Cersei it was me. The juror has a lawyer. Hold on. Sidebar. I forgot to finish the story. I was so annoyed that I just got to questions, but there's more to the story. We're not done yet. So back to the Maxwell case to finish up the story that I meant to finish telling. The juror has hired an attorney. So the court had a new order today. No, this was the 5th. This all happened on the 5th. So also on the 5th, a lawyer filed an appearance. So much happened on the 5th. I wish these were time stamped to know when these were coming in on the 5th. Juror number 50 already has a lawyer. So on the 5th, the government filed a notice. The defense filed the notice and request, the letter request for a mistrial, and an attorney for juror number 50 already filed an appearance, which seems really fucking fast to me. Like this all went down the same day. How did this person find a lawyer and sign a retainer agreement the same day? Like, how did this all happen in a day? I have questions. So the juror already has an attorney that has filed a notice of appearance from the Spodek Law Group, great Spodek Law Group, but also the court then filed another order saying a notice of appearance has been filed by retained counsel. So that order of appearance got filed before the court was gone for the day. All of this happened in a day. In the first week of January, which is when we're all kind of like, what day is it anyway? Or maybe it's just us because we've been snowed in. This all happened in a day. Retained counsel has communicated with the court that the juror does not wish to have counsel appointed. The court will not appoint CJA as indicated in the prior order. The counsel is directed to review docket number 571. How did that all happen so fast? Legitimately, I don't know. That's a fast day. That juror was like, how did that juror know to contact counsel and to get an attorney? The juror shouldn't be on pacer pulling things up. How did they know? I have so many questions. Anyway, sorry. I meant to finish that and then I got distracted. So, Bethany, yes, other jurors can testify. Hello, Celine. Absolutely off topic. First live in a while. Good to see you. But I got a job in promotion and I'm celebrating with a peyote IPA. Love your style. Cheers and congratulations to the promotion. Whoop, whoop. Let's see. Question, what if juror number 50 is lying about what they said in deliberation? If that's true, I'm sure we will hear about it. I'm sure it will come up from other jurors. We will see. It'll be interesting to see if between now and then any of the other jurors give media interviews, wouldn't it? So I'm assuming that they have to sign the questionnaire. Yes, they do. And yes, it's a legal document sworn under penalty of perjury. Question, what if the juror, okay, we got that. I think we've covered that question. So if they lied about what they said, it will come up. I'm sure they will ask another juror or two, but we'll see if other jurors talk about it in the media. Let me try to get to a few more questions, and then I'm going to go back and get to a few of the super chats from the beginning. Question, watching the sentence of the McMichaels today, the prosecutor and judge specifically mentioned remorse, and I'm wondering how much does a lack of remorse play into a sentence? It does play into a sentence. It depends on the judge, but it's not just at sentencing, it's at all. It's in interviews with police. These defendants testified, it's in their testimony. A lack of remorse plays in because it's one of the components of sentencing. Does the person appreciate what they did is wrong? Do they appreciate why it's wrong? Do they feel awful about it? Do they not give a shit? Remorse absolutely matters, and lack of remorse absolutely matters. So, for sure. So, I'm going to answer this. Stewart said he was abused, but not sexually. That's not what he said in the interviews. So in the interviews, he said he was a victim of childhood SA. So I've never heard of galaxy hair. Just Googled it. Very pretty. It is pretty. It would be a whole lot, but it is pretty. So we're 200K for fun hair. Question, non-American, how long could Maxwell be held in jail without a sentence? Well, if it's pending trial, until trial happens. So until trial happens, you're not supposed to be held in custody like longer than your potential sentence could be. There is a right to a speedy trial, but the defendant can waive it. And until they're done. So, especially if they waive their right to speedy trial, which they might because they need the time too. The defense might need the time as well. Question, how much trouble can this juror get into legally? We've talked about contempt potentially and perjury potentially. It really does depend on what was said in voir dire and in that questionnaire. So it will depend on facts that we do not have. Also, why do you think there was not more victims able to testify? There were so many. I don't know why the government chose to prosecute it the way that they did. It could have been people that didn't want to. It could have been people that have already, there was a large victims fund. People who've already signed agreements with the victims fund and were like, I don't want to be involved in this mess anymore. It could be that people refused to cooperate, that the timing was too far gone. I don't know why that's what the prosecution chose. Captain We the Barmy said Rebel Wilson went to the Harvard equivalent of law schools in Australia. Google, you'll see she actually had to prove who she was. Imagine asking your mom, do we have pictures to prove who I am? That would be very interesting. That would be very interesting. I will absolutely. Now I'm going to go down a Rebel Wilson law school rabbit hole. Question, won't the pretrial motion basically receive identical rulings and be unnecessary if they go before the same judge. Jonas, no, because things could have come up at trial that are now subject to pretrial motions. The pretrial motions from before would probably have the same ruling and not be reconsidered. But now that you've had all the evidence and all the testimony, they can do pretrial motions on, oh, this victim said this, they're not allowed to say this, or we want a new expert to do this. There can be new things because of the prior trial. That's a fantastic question. Thank you for asking. Let's see. Beth said if another juror had disclosed this instead of the juror who actually said did this, it still would have been an issue, right? It would have been harder to determine that it was an issue, but it still could have been an issue because if none of the questionnaires of the jurors, and they're going to have a binder and a file with all of those questionnaires, if a juror said, yes, we were very persuaded by one of the jurors who told us about their own experience and told us all of this, the lawyers would have gone back through and been like, well, what juror was that? Because we don't have anything here. And then probably would have asked the court to do an inquiry and bring all the jurors in and start questioning them. So yes, it still would have been a problem. It just makes it easier to figure out who caused the problem when it's the person who's speaking. So, Frederick said, question, do we care? I appreciate this question. Do we care if a monster is convicted, guilty, and jailed? I know it's unethical, but so is sex trafficking. So yes, and here's why. When we have constitutional rights, this is a personal standpoint. I don't believe they can be flexible just because we don't like the defendant. Everyone's rights have to be equally protected because that's the only way to protect the innocent. The only way to protect people who are wrongly accused, who shouldn't be prosecuted, is by protecting everyone. And so even defendants we hate, the process has to work properly and the system has to work the way it's intended to work, which means everyone's constitutional rights are protected. And we should always strive for it to work that way in every single courthouse, before every single judge across the entirety of the US. Constitutional rights should not be flexible based on whether we hate what somebody did, because that will allow for all manner of atrocities. The rule of law has to come before emotion, opinion, political expedience, viewpoint. It has to come first. So even though we can hate the result, we have to say, hey, we have to do this right. And this isn't done right. So we have to do it again. So that is why. But I absolutely get it. It's just like, you know, if Maxwell was being tried for lesser crimes than what she's being tried for, we can't be like, yeah, but she did so much worse things, we should just convict her for all the worst things. You can't do that. You have to look at what people are before you on the court. So protecting the constitutional rights of everyone is the only way to protect the constitutional rights of anyone. So I get it, but nope, I don't see them as flexible. And I don't think that they should be. So I must hear more about the juror asking you out. I think, did we talk about that in a members only live stream? I think that we did. I will have to tell that story again, but I know I've told it. I just don't remember when I've told it. At some point, I'm going to have to start clipping down the law stories. The juror looked a little bit like Gene Simmons. It was very strange. That he was asking me out in the middle of the trial. And I'm like, sir, you can't talk to me. Sir, you can't talk to me. And then very embarrassing to have to go tell the judge and have to have a hearing on it and then excuse the juror. For the Paw Nerds Emotional Support Fund, Fred, thanks, buddy. Where'd George go? He didn't climb back up to George. George was like, I'm not doing this, and left. George was like, I am out. I am out. All of you are like, tell us. All right, I've got to go to a few other super chats that I missed from the beginning. Oh my God, we're at almost 2.5 hours. I love, can you tell that I love answering questions? Did Britney respond to her dad's last motion that you covered where he asked for attorney fees to keep being paid on the account? Not yet. And I will look if they do. Oh, you guys are like, check back and see if Dr. B ever answered your text. Probably not. Nope. Nope, not at all. How did the press get the name of the juror, or did the juror go to the press? The juror asked to be identified by a first name and a middle name. And it seems that the juror went to the press. The jurors are free to talk to the press. The press is not generally allowed to contact them. So, how they connected is something I have a question about as well. So let's see. Question, when you say demonetized, is only for a little or for a lot? Well, it's for the whole video, so it depends on how the video performs. But it's not really the money that is the biggest issue for me. When YouTube demonetizes things, they do not share it. And when they do not share my content, it makes it harder for the channel to grow and for people to get the facts, not the fuckery. So it's more of the reach issue than it is the money issue. The money issue is annoying. I am a full-time content creator, but the reach issue is more of the problem for me. Question, have you seen Logan's update today about Alec Baldwin? I did not see an update today. I saw his long video on it, but I did not see an update today. Today, I was prepping for next week's podcast and for tonight. And if you follow me on Instagram, I was putting up a new dry erase in my office that took a substantial amount of time because it is giant and glass and it has to be exactly spaced. There was lots of measurements. Thankfully, Dr. B is very good at that. That. Okay, I'm going to get to a few of our older super chats, but I will go look for Logan's video. Thank you, Allison, for the super chat. And with Observe, I need to reach out because there were a few times in his videos where he's like, well, I'm not a lawyer. And I'm like, I am. I talked about it. Come watch my video. I need to send it to him. I talked about it. So let's see. Question, have you heard that the Vanessa Bryant and LASD case is moving forward to trial? I'm sure that it is. There were some discovery things going on, and once it does go to trial, I will be covering it a bit more. There were a lot of pretrial motions. There was stuff she had to turn over, but I'm sure it will. There's been, though trials in LA County are going very slowly, there are continually issuing new orders to extend trials. So trials aren't happening as quickly as they should. So let me get to some of the super chats from earlier in stream that I missed. Elisa had said, waiting to get my groceries at Walmart. I'm 20 in line and parked. I mean, that sounds like a long, long line to get groceries. I love having groceries delivered. It's been one of my favorite things lately, especially when our whole family got sick. I was like, can we just deliver groceries? Yes. Perfect. Panaz said SLC feels great. I bet it's nice and cold in SLC. Did you guys see that Mary Cosby didn't go to the Real Housewives of Salt Lake City reunion? Like, what? Thank you, Janice. Oh, thank you, Captain We the Barmy. I saw the ABC special, Not Enough Emily. I mean, I feel like it was a good amount of Emily, but thank you. If you guys haven't seen that, it's on Hulu, and I'll share some of the clips that are up on their YouTube channel on my channel as well. So, yes. I would always love to see I would always love to work with Observe. I think he's great. So, Emily, you have to see the 1-minute video of that juror saying, no, they don't ask about your essay history. I was floored after hearing those jury questions. Oh yeah, they absolutely ask. They ask in like more than a couple ways, and then they directly ask, because they don't always ask. They ask when it's relevant to the nature of the case. Just like if it was a robbery case, they would ask if you'd ever been robbed, or if anybody's ever stolen things out of your car. They would ask about that kind of crime. They ask about something that is specific. So it was absolutely a question. Let's see. Question, will you be attending the Jen Shaw trial to give us a play-by-play? Brittany, I want to. I'm trying to figure out logistics, but I want to. So at least for some of it. Question, why is a juror telling their applicable experience wrong? The telling of the experience isn't wrong. Isn't that the point of a juror of your peers so that common sense and general life experience can be exercised? That the telling of the experience is not wrong. It's the not disclosing the experience on the juror questionnaire or during voir dire that is the issue here. If the juror had disclosed it, the juror would have been questioned about it and likely dismissed by the defense in all reasonable practicality. If the juror doesn't disclose it and can't be asked about it, then the juror has not fully disclosed and cannot be a fair and impartial juror and has not disclosed their past. And that can be grounds for a mistrial because it actually mattered because the juror used that experience to sway the other jurors. So it's not the retelling of the experience, it's the not disclosing it. That's a long way to answer that. So yes. I have a fever and the only cure, I need a cowbell sound in my thing. So thank you. Janice said, didn't figure out how to attach a note to the super chat. Thanks for spreading the knowledge tonight. You're welcome. That's what we're here for. That is exactly what we're here for. So, Boxy, I forget to go back on things I've already covered. Voir dire is it's spelled like voir dire. It is the process of questioning jurors. I believe it was the chat who told me what it meant in Latin, seek, say, or say, speak, something like that. But voir dire is, I think voir dire is how it's properly pronounced, is the process of the lawyers asking the potential jurors questions before they become jurors on the case. And after you ask them questions, then the attorneys have the right to exercise peremptory challenges, meaning they can kick off a juror for legal and proper purposes. There are some things you cannot yeet a person for, but there are many, many things you can yeet a person for. But also, the judge can remove or strike jurors for cause, saying this juror cannot be fair, and they're removed for cause. So there are two ways that jurors can be excused. But if somebody is not truthful, you can't properly question them about it because they didn't tell you. Sorry, you guys are like, it's French. Apologies. I have offended the French Leonards. I am sorry. So thank you. Let's see. Question. Would there be a different outcome based on whether the juror lied on the questionnaire, the deliberations, or to the media? Yes. If the juror was truthful in the questionnaire, then there isn't an issue. If the juror lied to the media, and didn't impact deliberations, then I guess there's really no harm, no foul because they didn't impact deliberations. The only way to know that's to question other jurors, which I'm sure the defense will recommend questioning of the other jurors because I think you would have to at that part. So, let's see. I'm going to try to get to some of the other super chats from earlier that I missed. Kate B said, I got an Encanto tattoo. I may be a little obsessed. I mean, we love getting a tattoo. I hope it's lovely. I'm sure that it is. It's fantastic. Jeremy said there's also a Heathers the musical. Oh my God, I'm going to go down a musical rabbit hole of musicals I didn't know existed. That's fantastic. Jordan said, first live stream I've been able to make. New member, so happy to have joined. You and Natalie are my favorite legal analysts. Thank you. It's always weird. I don't know. I lean towards on YouTube legal commentary because it feels like that's what we're doing, but it really is legal analysis. But I don't know. Analysis feels so like stuffy to me. Commentator feels better. It's like, well, George, here we have some fuckery afoot in the Maxwell jury. What do you think, Bob? I don't know. It feels right. Caitlin said, every time I watch, I feel the need to go into my prime bank of 90s and 2000s movies. I mean, my brain really does get stuck there. I had one of my dearest friends visiting here in Tennessee who had not seen Easy A, and I'm like, sit down, this is what we're doing immediately. And we had a very a very enjoyable night drinking whiskey and watching Easy A. She's like, I have never ever seen this at all. Jordan said Judge Wimsley in the McMichaels sentencing was powerful and gave me chills. His speech was pitch perfect. I will go back and watch his speech. I had not had a chance to watch it. I have seen some judges really lean in to defendants. I have seen some fiery sentencings, but then when they go to do sentence, you kind of get the neutral face. There was a judge on, was it the murder for hire? It might have been the murder for hire case at sentencing, but I just remember this judge looking at the defendant and be like, literally in all of my years, I have not seen anything more depraved, more despicable, and less human. And there like isn't enough prison in the world, essentially, that is justice in this case for what you did. It is horrifying. And just lean in. So I will look at what the judge said to the defendants for sure. I wanted to just cover the sentencing, but I know that that's out there. There's not much I can add. There's not much I can add commentary on a judge commenting, unless it's a judge coming unhinged and saying, don't get brazen with me, because that happened live. Nicole said, for the demonetization of this video, thank you. Thank you guys for all this so Emily can speak freely. I really try to kind of play within the lines of where YouTube is, because I know my content is educational. I know that it's needed, but I also know that a lot of YouTube runs on algorithms, and the algorithms pick up on particular words that are like, you said the no words. But most of the time when those get reviewed, it's fine, but it just doesn't push the videos the same, which is probably why when LawTube's like, we don't grow the same way other channels do, it's because the content is not always, what they consider advertiser friendly until they go back and look at it. We generally have a good relationship, but there are times when it is hard, which is why I'm glad I have other ways to communicate with the Law Nerds as well, on Twitter, on Instagram, over in the Law Nerds community at lawnerdsunite.com. I have the text crew. I have other ways to communicate just in case. So that is important. Let's see. War Prime said, this is like lying on your job application saying that you did not go to jail when in fact you did. I feel like it's worse than lying on a job application, because the implications for the victims and the witnesses is so big. Excuse me said, what if he is a lying liar? Oh, we talked about that. Does Juror 50 have charges coming? We'll see what happens. I mean, if they lied on that form, it's perjury. Perjury can have various consequences. It can also be contempt of court. And I think that's I think that's all. I think I got to all the super chats. Yay. I think we got to all of them. Legally Blonde, the musical, is by far my favorite. It's fun. Mean Girls and Beetlejuice are pretty good too, as far as musicals. I need to listen to the Beetlejuice soundtrack from the musical. I enjoy the movie, but and Mean Girls too. I love the Legally Blonde soundtrack. I've not seen any of them. I need to go find them. Regarding questions, do verdicts have to be unanimous? It seems to me that one outlying juror causing an inconclusive hung deadlock jury doesn't seem right. If 11 of 12 people want pizza, you get pizza. For criminal trials in the US, it has to be unanimous. It must be a unanimous verdict. I have had 11-1 hangs. It's very, very frustrating. I had an 11-1 hang when they were hopelessly deadlocked. When the jury came out to tell the court that they were hopelessly deadlocked, there were 11 jurors sitting there. As I banged my mic, there were 11 jurors sitting there, arms crossed, glaring at the one juror, and it was juror number 1 that was hung, but glaring at the one juror. Not that I'm traumatized and remember this, because I was so angry. Literally, like arms folded, just stink facing the one juror, and the one juror was like, we retried it and convicted. But They might have pled. I might be conflating two cases. Either way, they ended up being convicted, but 11-1 hangs are very frustrating, but they do happen, and you can see it, and all of the jurors, 11 of them wanted to stay afterwards and just talk shit on juror number 1 and why juror number 1 wouldn't deliberate and wouldn't listen, but it was hard because they didn't come out and say this juror is refusing to deliberate, because refusing to deliberate is something where you can have the juror questioned, other jurors questioned, and possibly replace somebody with an alternate if you're told before they hang. But I think at the end of the day, he just didn't see it the way that they saw it. It's not like it's not like la la la, I refuse to deliberate. It's like, I just don't agree with you. And that's jury deliberations. Someone's allowed to not agree and to not be swayed. Um, Free Speech Fund, thank you for covering all the things, sending love. Well, thank you. It's like the no words fund at this point. I'm gonna get to just a few more, and then, oh my God, it's been almost 3 hours. Y'all. Y'all. Angel's lies to keep control. I'm sure there's a story. Is GMAX on life watch while awaiting trial? She has been on watch like almost the entire time she's been in custody, and has complained multiple times to the court because it keeps her being woken up throughout the night, and it keeps her with the lights on in her cell 24/7, which is not healthy for people, and it keeps her in isolation, and her lawyers have asked her to be taken not in isolation, not on watch, so that she can get like a full night's sleep and have the lights off and stuff like that. But she has been on watch for a substantial amount of time, and it's been something that has been brought up repeatedly. So yes and yes. The Billy Joel musical Moving Out was fabulous. I love that you guys are just I love that we're just talking about musicals. We saw Frozen the musical with the kids, and it was fantastic. So thank you. Motivational wait, Emotional Support Fund donation. Thank you so much. I'm going to do 2 more questions, and then I'm going to say goodnight. I can't believe it's been almost 3 hours. I can't believe it's been 3 hours. Kara Giver of Hugs, question: how do the courts get away with the racism and classism that seems to be baked into the system if everyone has to have the same rule of law? So I am definitely not an expert in classism and racism within the system, and I think there are probably people much more qualified than I am. But everyone has the same constitutional rights. But when you look at who gets stopped by the police more frequently, and who has the ability to pay, when we talk about classism, which the money in legal is a huge issue. When we talk about somebody like Maxwell, who has the attorneys to bring all of the motions, and this motion would come up no matter what, this mistrial, but has the money to bring all of the motions, the pretrial motions, do they get a better tier of outcome because they have afforded the lawyers to bring all the motions because they have the money to do that, versus somebody who has an attorney who is court appointed? Not that they are not good attorneys, they are, but do they have the same time and resources that a private attorney has? No, they don't. So does that bake into the system that people who have less money don't have the same opportunities afforded to them, but systematically who has less money? And that is where you start seeing those class divides and some of those race divides coalescing together. And that is, again, something that sociologists, I think, work on quite a lot, is how to undo that out of the system, because it is supposed to be the same rule of law for absolutely everyone. It is supposed to be. That's why there's sentencing guidelines. So if you commit this crime and have no priors and it's within this range, that the sentences are somewhat in step with each other all across the nation. You shouldn't get sentenced to more time because you got arrested in Georgia versus California, but that can happen. Hopefully that helped answer that question. I hope so. Fast like the Flash, I need a lawyer friend like jury number 50 on the spot. There's an Addams Family musical too. Oh my God. 3 hours, no wonder I'm hungry. Me too. Can jurors give recommendations for sentencing? No. The jurors are the finders of fact. They have nothing to do with the sentencing. Come From Away is a great musical. Jessica, the soundtrack for Come From Away is one of my oldest's favorite musical. They were studying parts of it for theater because he loves theater. So he and I have been enjoying that soundtrack quite a bit. So let me see. You guys, Addams Family, thank you, mods. It is time to give a huge thank you to our mods because our mods keep this chat, well, our mods and our law nerds keep this chat an amazing place to be, making sure that as people come through to troll based on topics, that they do not get very far because this is where we have considered conversation on the internet, and that matters so much. I am also getting hungry. Well, it's almost 10 o'clock. We have got to go. For sure. Law nerds, thank you for being here. A huge thank you to our mods who are fabulous as always. A reminder that it is my intent to be off next week. There will be a new podcast episode live probably on Wednesday. There will be a members only live stream on Thursday. Those are the things we are doing next week. If all hell breaks loose, might I sporadically go live? I will talk to the mods. It might happen. But it is my intention that it does not, and I will keep you updated on the things that are going on Twitter and on Instagram. If you don't follow me there, I'm at the Emily D. Baker. Why wouldn't you follow me there unless you're not on those platforms, at which case I totally understand not being on social media, and I will keep you updated in the community tab on this channel as well, so turn your bell on. All right, let us say goodnight. Thank you for being here. Thank you for being a law nerd. Stay hydrated. May the odds be ever in your favor. And I will see you live in the next one, which will be in like a week. So, well, not a week. It'll be a week and a little bit because it'll be Coffee and Cursey Words when I am back with y'all. But we've got a lot to look forward to. There's a lot of court happening on January 19th. So we will definitely have a lot coming up. There are Toddy Westbrook updates that will be coming up that need to be coming up there are motions, there are things happening. And then there is another lawsuit with Shalene Johnson and Dr. Laguna. All of those things are coming up. So I will be bringing some of that stuff to the podcast and then some of it back to our first live stream back together. And I will see you in the next one. All right. It's time. It's really time. It's time. Fred, we're going. Let's go eat. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.